Members of the Commission, staff of Parliament, Chief Parliamentary Council, presenters, visitors in the gallery, distinguished ladies and gentlemen. This third meeting of the Joint Select Committee on the Integrity and Public Life Bill is called to order. I propose, can we have a motion that the minutes be taken as read?
I so move.
So moved by Senator Franklin and seconded
So seconded, Chair.
by Senator Cummins. Any matters arising? There being none, I'd like to move swiftly into the presentations before this committee today. We hope to receive as many of them as possible, and we're expecting a total of about 7 presentations to the committee this evening. I would ask all presenters to please bear in mind that in I think all instances you have submitted a written submission. We are giving you the opportunity to expand on it. We will be generous enough with our time to allow you to even go through parts of it, but please rest assured that members of the committee are fully able to read and digest what you've written. So we will not be allowing you to read over what you have already submitted. We will begin with Solutions Barbados. Solutions Barbados will be represented by Mr. Grenville Phillips and by Mr. Kenneth Lewis. And I'll ask the Marshal to show them to their seats. Please remember that the proceedings of this committee are being streamed live. Also, when you are speaking, please remember to press the button on your microphone. Mr. Phillips, I understand that you'll be the one making the presentation.
That's correct.
The floor is yours.
Thank you. Right. Well, the intent was to basically present what we have written to you. We just realize now that that's not what you would like. In that case,
Mr.
you wouldn't
Phillips,
mind
please
discussing.
present it, but
Oh.
I don't want you to read it for us.
Yes, that was the plan. So in that case, if you have read it already, I wouldn't mind if we could discuss the items of it that you were in disagreement with. So what I could do is I can go through some, and if you're in disagreement with them, I wouldn't mind using my time discussing so that we could perhaps converge towards a common view.
At this point, the committee is not minded to indicate agreement or disagreement.
Okay.
We have a number of presenters
Yes.
who we all want to hear, and we certainly wouldn't want to fetter our positions by agreeing with you and then finding that after we hear the distinguished presentation from the Ombudsman,
Yes.
that we agree instead with him.
Yes. Well,
So
not
please
so much
present,
agreement.
please
Yes.
present. I'm giving you liberty.
Okay.
I think we anticipate that each set of presentations would have in the region of 15 minutes, so use it as you see fit.
Okay, thank you. So thank you for giving us the opportunity. I believe it's a mark of great political maturity to allow this. It's very important that legislation does what is intended and prevents what is not intended, but which may be inadvertently allowed. To this end, the bill was scrutinized to determine how vulnerable it was to having the commission, the officers or tribunals being politicized, guilty persons being protected and going unpunished, innocent persons being targeted and persecuted, whistleblowers being discouraged from reporting evidence of corruption, and persons being discouraged from serving in public life. So the following recommendations are made with a view to eliminating or reducing these vulnerabilities. And if for your convenience, we reference both the section and the page numbers. So on section 4.1, which is page 14 of the bill, it says the Commission should record gifts not only forwarded as stated, but forwarded and received by persons in public lives. Therefore, we recommend that it should read, gifts forwarded and received by persons in public life. In section
Mr.
4.2.
Phillips,
Yes,
if we could pause, though, one of the very keen members of the committee pointed out to me that the section says that you are to receive and keep, the commission will receive and keep record
yes,
of all declarations, statements of registrable interests, and reports.
yes.
So what is being received are, in essence, reports, not the gifts themselves. So I'm not sure how you would want to put the word received in there.
Okay, I'll check. and
Certainly, the
get back to
commission
you.
will not be receiving anybody's gifts.
No, not the gifts, reports of the gifts. So reports
The
of gifts.
reports are being forwarded
Yes.
to the commission by the persons in public life.
Yes. So we'll check it and write back on that, clarification on that one. So on section 4.2, the commission should at all times be independent and not be under the direction and control of any person or political party. Therefore, where it states the commission may not be subject to the direction and control, we think it should read, the commission shall not be subject to the direction and control. Section 8.2, since the consultants hired by the commission are unlikely to be selected through public tender, a specified salary or fee cap should be specified to prevent overcharging. Therefore, where there is no public tendering, the rate should be paid, should be the same as those paid to public workers in the schedule of personal emoluments. If not, then you allow tendering. Section 9.1, since the scope of the investigative officer's authority is very broad and deep, and he or she must rely on his or her discretion, it is important that the qualifications of such a person be specified. To reduce the risk of abuse by another administration, it is recommended that he or she be a chartered professional at the grade of fellow, that's the expert level. Now, fellows of professional bodies are normally too invested in their professions and have complied with their code of ethics for over a decade. Therefore, they are more likely to act in a fair, independent, and unbiased manner. Now, there's precedence for this. The government of Barbados already specifies posts that require qualifications to the grade of fellow of internationally recognized professional bodies. For example, the post of actuary in the Exempt Insurance Act, Cap 308.8. Section 10.3, the Commission is not restrained by the rules of the Evidence Act, which were designed to protect us all. While it's reasonable that opinion evidence may be relied on during the investigation phase of the process, the bill should clearly state that the Commission must not rely on any opinion evidence to determine someone's guilt. Section 11.1b, this section appears to entitle a summoned person to be compensated for expenses as if he had been summoned to attend the Supreme Court on a criminal trial. However, the person can only be paid whenever and however the Minister of Finance decides, that's in section 11.2. The Commission can also decide to simply not allow the summoned person to claim any expenses whatsoever, that's in section 11.3. Now, the common trend when persecuting political competitors is to attempt to bankrupt them, which can automatically disqualify them from being candidates. To have a person continually attend hearings for weeks can accomplish this aim, which is why the Evidence Act entitles innocent summoned persons to be reimbursed for both their time and expenses. This is natural justice, since a person cannot refuse to appear when summoned without consequences. The Evidence Act appears to be carefully designed to protect innocent persons from political abuse. Section 11.1b should therefore entitle a person to time and expenses to be paid within 3 months from the consolidated fund as granted to the Commission staff in section 33.5b. Therefore, our recommendation is that sections 11.2 and 11.3 should be omitted from the bill. Section 11.4e. If a person insults a member of the Commission, then he is liable to be fined $10,000 and imprisoned for 6 months. A person who is subjected to obvious unfair treatment for as long as a politically compromised commission decides, knowing that he will not be reimbursed for his time, is vulnerable to objecting improperly. Further, a politicized commission can entrap and frustrate an innocent person. The penalty for insulting a member should therefore be reduced to $500, which should be enough to bring the offender to his or her senses, which should be the Commission's aim. In Section 11.5, a person shall not be compelled to incriminate himself. However, according to Section 11.4, he is liable to be fined $10,000 and imprisoned for 6 months if he does not turn over documents. It should be clarified whether he can be compelled to turn over documents that can incriminate others, who in turn will likely incriminate him. Also, what prevents a person from answering every single question with the sentence, "I cannot answer that question because it may incriminate me"? Section 12.a. While the Commission may require matters to be verified and witnesses to be examined under oath for preliminary inquiries, the Commission must do these things when determining someone's guilt, and the bill should specify this. Section 14D. The Commissioner of Police must provide constables to do whatever the Commission directs. To give guidance to inexperienced constables who may be ordered to do something unlawful and think that they can simply give the excuse that they were simply following orders, it should read, perform such and add lawful duties as the Commission shall direct, not just any duties. Section 12.2, an investigative officer shall, after making an arrest, deliver the person to the custody of a member of the police force. However, to reduce the risk of rendition, it should read, an investigative officer shall immediately, after making an arrest, deliver the person to the custody of a member of the police force. Section 17.3, to address the seizure of computers and other information critical to the functioning of an accused person's legitimate business, the accused person should be allowed to retain copies made under the supervision of the investigative officer. Therefore, a new item should be added, say Section 17.4, to suggest the following. Where the material to be seized is, in the opinion of the owner, critical to the operation of his business, he shall be allowed to retain copies made under the supervision of the investigative officer before it is seized. Section 19.2, to reduce the risk of unnecessary delays, a time limit should be specified for which the Commission must refer a complaint to a panel, and we suggest within 1 month. Section 21.1a, frivolous, vexatious, and bad faith are subjective assessments that should not be provided to the panel as an excuse to avoid pursuing an investigation. A person complaining about seized documents may seem trivial to a lay panel, but not to a contractor whose critical documents were seized and is liable for liquidated damages of $50,000 per week on a construction project. Section 21.1b, a lay panel may decide that an investigation may be deemed not necessary since the seized documents may have been returned. But what about the quantifiable losses due to the contractor whose documents were seized and whose contract was now terminated as a consequence? If members of the panel are not knowledgeable in the field being disputed, then the bar should be set low for an investigation to proceed. And I mentioned the construction cases because most corruption worldwide is with construction projects. Section 32.5, once a person has retired from public life for 2 years, then he cannot be investigated. This is a glaring loophole for persons who have already retired. Also, persons can easily walk over this low hurdle by directing that bribes be paid to them 2 years after their retirement. It can take over a decade for evidence of corruption to be uncovered by responsible junior staff. If a time limit is to be specified, then the minimum should be the longer of 10 years after the person ceased to be in public life, or 5 years after the date that the commission became operational. Section 33.1, the Governor General should appoint a minimum of 2 persons to the tribunal rather than the stated 1 person, and they should be fellows of professional institutions for the reason previously stated in our recommendations to Section 9.1. Section 33.3, again, the same recommendation. If a limit is to be specified, it should be longer of 10 years after the person ceased to be in public life, or 5 years after the date that the commission became operational. Section 33.5B, the innocent person should be reimbursed for both time and expenses, not just expenses, and these are with the commission. Section 35.2, the $20,000 fine is too easily affordable for those who intend to pay someone to reveal declaration records. It should be at least $200,000. Section 36.3, there was simply a question, what happens if a person simply refuses to pay the fine? Perhaps there should be an imprisonment provision for such blatant refusals. Section 43.1, the $15,000 fine and 1 year imprisonment is too lenient to be an effective deterrent. With such affordable consequences, a person can simply take the chance of not disclosing information knowing that he can easily afford the fine. A minimum fine of $150,000 and/or a 3-year prison sentence is an effective deterrent. Section 45.4, since relatives and friends can also offer bribes, this clause, and I've written there section 54.4, it really should read 45.4. So if you could change it on yours, 45.4 should be omitted. Every substantial gift should be reported like in section 46.1. Section 48, this loophole for persons who have already retired should be closed by specifying a period of the longer of 10 years after the person ceased to be in public life or 5 years after the date that the commission became operational. Section 54, there is normally some sort of collusion with corruption. Therefore, every participant should benefit from the same deterrent by facing the same penalty as the accessories, and that deterrent should be the fine of $500,000. And this is relevant then to section 54.1A, 54.1B, 54.2A, 54.2B, 54.3A, and 54.3B. Section 56.A, this loophole allows a person charged with corruption to be found innocent if he can claim that he had no knowledge of the circumstances giving rise to the act of corruption. Therefore, a person can simply reverse engineer the corrupt activity to be able to claim that he had no knowledge not of the corrupt act, but of the circumstances giving rise to the act. This clause places too much uncertainty and doubt before the adjudicator. Therefore, it should not be a specified defense to bind the adjudicator. Section 59, maliciously is too subjective an offense since anything can be misinterpreted as malicious. A better description of an offense that can be better measured is knowingly, and it was used in similar circumstances in section 36.1E. Section 60.1, to reduce the risk of whistleblower victimization, especially when there is no monetary reward, anonymous reporting should be allowed. It should be noted that anonymous reporting and financial incentives are proven ingredients of an effective whistleblower program, which the bill does not contain. In the United States, their highly successful Securities Exchange Commission's program allows whistleblowers to report anonymously and rewards them with up to 30% of the amounts recovered. Anonymous reporting and financial incentives should be a part of the whistleblower program. Section 63, to prevent unnecessary delays, a 3-month time limit for the prosecutor to act should be specified. Section 65.4, again, this loophole for persons who have already retired should be closed by specifying a period of the longer of 10 years after the person ceased to be in public life or 5 years after the date that the commission became operational. Section 76.1, this affordable $15,000 fine is not an effective deterrent for this offense. A minimum $150,000 fine is an effective deterrent. Section 77.2, this section contains a grammatical error. It should read, contract of employment includes an agreement. Section 79.2, the penalty should be the same as recommended for section 35.2, namely a $200,000 fine and/or 3 years imprisonment. Section 79.3, both the receivers and givers of confidential information should face the same deterrent sentence of a $200,000 fine and/or 3 years imprisonment. Section 81, the person should be liable for the consequences of actions done in bad faith, and the bill should specify that. For example, if the investigative officer would not allow an accused person to retain copies of his or her commercial documents, resulting in quantifiable damage to his or her business, then the investigative officer should be liable. Now, with the first schedule, Section 1A, the Chartered Accountant Commission member should be at the grade of fellow for the reasons already explained in our comments to Section 9.1. Section 1B, to reduce the vulnerability of selecting someone who is not sufficiently invested in their profession to act in a fair and independent manner, the clergyman commission member should have a minimum of 10 years of pastoral responsibility. Therefore, he or she would most likely have ministered to persons who support both established parties. To further reduce the vulnerability of a partisan appointment, the person should be recommended by the Barbados Evangelical Association or a similar representative body that would not want their reputation tarnished by recommending a known partisan priest. Section 1E and 1F, to reduce the risk of unfair and biased decisions, the Governor-General should appoint a chartered professional at the grade of fellow for the reasons already explained in our response to Section 9.1. Section 2B, any person appointed by a minister should be disqualified from membership of the Commission since they are likely to remain loyal to the one who appointed them. Section 2C, a person who is a minister should be disqualified from membership of the Commission since there is the obvious appearance of bias and politicization of the Commission. And that ends our submission, and we thank you very much for allowing us this opportunity.
Thank you very much.
Thank you, Mr. Phillips. I understand that both you and Mr. Lewis will be available for questioning from the panel.
Of course.
Thank you.
The floor is open to members of the committee to engage with these representatives of Solutions Barbados. The Honourable Mr. Atherley has the floor.
Mr. Phillips, good afternoon. Thank you for your submission, your presentation here today, and for your continuing interest in matters of national concern.
Yes.
In an earlier manifestation,
Yes.
declaration of your organization's concerns, you had made a reference to Section 6.2 of the bill. That does not appear in this document which we got today.
That's correct.
Have those concerns been allayed? Do you still have an issue with Section 6.2, which speaks to the Commission being treated as a law enforcement agency for the purposes of receiving disclosures of information which are relevant to its functions from any law enforcement agency, including a foreign law enforcement agency?
Yes.
Have your concerns?
Right. Section 6.2 was mentioned simply to identify that the Commission is an extremely powerful commission, and they have opportunity to do great good, but also, if it's politicized, significant harm. And it was, if the suggestions that we put forward are addressed, even if they are not agreed to, or at least discussed. So if someone doesn't agree with them, they can let us know what they don't agree with, and we are happy to discuss it further. Then fine. But it was simply put there so that we all know that this is an extremely important commission that can do great harm.
But my reading of what you submitted earlier suggested to me that you felt that the commission, as framed in the bill,
Yes.
is likely to be a politicized entity.
Yes.
And given the powers under 6.2, your concerns would be that whoever controls to use your words, whoever controls the commission can clear their guilty friends and punish their innocent perceived enemies with impunity.
Yes.
Now, the question I really had is, have your concerns been, your fears been allayed? How would you go about addressing those concerns if they have not been thus far allayed?
Right. we sought to address those concerns with our submission. So the bill as written can easily allow guilty friends to go unpunished and innocent persons to be persecuted, as written right now. And that's why we submitted these 46, or these suggestions or recommendations to 46 of the sections that would allow the bill not to be so easily, not the bill, the commission not to be so easily politicized. Because right now, it can be politicized extremely easily. And, well, I guess throw that in, I expect to be one of the first to be persecuted, so I'm not under the protective umbrella of either established party. Yes.
While the other members of the panel gather their thoughts,
Yes.
I just want to engage you on your comment on clause 32.5, which is more or less repeated at clause 48 and at 65.4. All of these sections, all these clauses as currently drafted indicate that the intention of Parliament would be to have a limited period of time
Yes.
after a person leaves public life, upon which occurrence the ability to further investigate them comes to an end. So
Yes.
at 32.5, it says, an inquiry shall not be commenced after 2 years from the date on which the person ceased to be in public life.
Yes.
It is your view that this period is simply too short and should be extended?
Yes, for two reasons.
Yes, please.
The first being, someone could simply direct the person that's going to pay them a bribe to do so 2 years after they retire. And 2 years is a short time. Well, for us who are over 50. Secondly, it can take about 10 years for junior staff of maybe a firm or a company who's responsible to be promoted to an associate or a director and then uncover the corrupt activities. So because of that, because it takes about 10 years to discover corruption activities, 10 years is a better time rather than 2 years. Well, it should be, 10 years should be adequate.
I understand your perspective, but let's home in perhaps on clause 32.
Yes.
Clause 32 deals with the commission examining declarations that are made by persons in public life. That's the whole intent of clause 32, that when persons file declarations in public life, when persons in public life file declarations, that the commission would have the right to examine those declarations and to look into whether what is so declared is truthful and accurate and so on.
Yes.
Now, I think we would all agree that one of the challenges that Barbados faces is that the public service and allied agencies are all known for working relatively slowly.
Yes.
And I wonder if there isn't a case to be made for keeping this period of time short so as to ensure that public servants don't feel that they have, they can put off any inquiry into a declaration for 2 years, 3 years, or we can get to him or her
Yes.
down the line.
Yes. That's, so specifying a short period of time, if it was done for the intention of getting persons to speed up an investigation, that's commendable. But the reality is, it's also a loophole, and it's a glaring loophole, so that if someone wanted to receive a bribe, they just tell the person, all right, let me retire this year, and you pay me my bribe within 2 years. Someone's unlikely to say, pay me my bribe in 10 years, because they may die. But to say, pay me my bribe in 2 years is likely, especially as construction projects go on for about 2-3 years. Sometimes 5 years for a large one. And I know this because I work on large construction projects.
Excuse me, I have a little difficulty understanding that. You really feel that a person who is going to bribe an officer, and the officer says, well, you pay my bribe 2 years, I get my job done, you think, there's no contract, you can't sue him, if I ain't gonna pay you, you really feel like somebody, you want your money now.
Right. The corruption cases around the world are available online. You can actually read the transcripts.
No, that's not what I asked you.
You'll be shocked at what goes on.
No, that's what I asked you. I asked you if you
Yes.
really feel
Yes.
that there's nothing binding a person who has received, who has given offer to give a bribe.
Yes,
There's nothing binding those two parties,
yes.
You can't go and tell the police, I promised to pay him a bribe and he ain't give me my money
Yes.
or whatever else. You can't do that. So I don't understand what you're saying. It doesn't make sense to me. It might make sense to some other people. I said, but not to me.
Yes.
If you don't take your money up front, there's no guarantee that the fellow can say, well, I'm going to pay you that money in 2 years down the road. I'm not going to pay you.
Who knows why people take bribes?
I
Who
don't
knows
know.
why
I've never
people...
been on one, but what I'm
Yes.
trying to ask you is...
I'm not in the mind of the briber or the bribee. But I'm just saying what normally happens.
No, you know what I'm asking you?
Yes.
You think it's realistic that a person will postpone taking a bribe, taking some money from somebody down the road, and say, well, I want it in 10 years or 2 years or 3 years? Well, when you do what you have to do, you are either doing or forbearing to do something that you have a duty to do. And I'm going to pay that, you're going to pay the person for not doing his duty or for doing the duty to favor you. Down the road, when it's done, you don't going to pay him anything because he can't report you?
Yes.
You can't go and say, well, look, he did not pay me my bribe.
Yes, so we can rationalize it that way. But I'm no expert in doing wrong things. I try always to do the right thing. So I have no experience in this matter. All I can go by is the transcripts
Just
of
express
what
and
people
common
have.
sense, that's
or
what we're
people-
asking for.
Yes, but why do people take bribes in the first place, knowing that they may get found out, the embarrassment to their families and friends? Why do they do it? I don't know, but they take the risk. They assess the risk and decide, I'm willing to take this risk, and they take bribes. I don't know why they do it. I wouldn't do it,
You
but
don't
people do that.
postpone the bribe, you take it.
Yes.
That's the point I'm trying to make.
Yes, but they do that as well. So if that's what they do, that's what they do. Now, we haven't had a bribery case, I don't think, brought in Barbados, so there's no transcript in Barbados to look at. But you have them all over the world, Lesotho, and especially all over Africa. You have them. And you can go and take a look. They brought them in England. You can go and take a look at the transcripts. Crazy stuff.
I take it that no other members of the committee wish to ask any questions. Do you have a closing, very short statement?
Yes,
Very short statement.
very short. I cannot thank you enough for this opportunity and for showing the maturity of this administration. So I'm really encouraged, and I hope that this sort of thing continues. Really appreciate it.
Thank you very much, Mr. Phillips and Mr. Lewis.
Thank you very much,
Your
sir.
contribution is much appreciated.
Yes.
It occurs to me, though, that the disadvantage that members in the gallery have is that they don't have the benefit of the presentations that have been made. And at an appropriate time, I will ask the committee if there's a view that the submitted presentations can be made public on the website so that you could actually see, or you could have seen what Mr. Phillips was going to present and have an idea of the nature of the discourse. And I will try to think if there's also some mechanism for members of the gallery to make available to the clerk at the table any questions that you might wish us to posit to the individuals. But we can formulate that hopefully within the next couple of minutes, if possible. Mr. Phillips and Mr. Lewis, thank you. We now
Thank you.
invite the Kingdom Government of Barbados, represented by Mr. Steve Hunt.
I didn't. Huh?
Mr. Phillips, you're taking your leave, but you know that you don't need to. You have big construction contracts to go work out. We understand. Have a good day, sir. Mr. Hunt, you are solo.
Sir.
I'll give you 15 minutes to make your presentation and question.
Good evening to you. I want to thank the governor of Barbados for engaging the public in such a discussion like this to deal with the governmental affairs of the running of the country of Barbados in drafting such a bill based on the integrity legislation bill in public life. My presentation today, I submitted to an oral presentation, and my presentation is based on the governance of Barbados when it comes to corruption, as the bill states. And I'm here to represent the people of Barbados, being a voice and an advocate for the people of Barbados when it comes to good governance in Barbados. According to our Constitution, we expect peace, order, and good governance. And under civil democracy is what the government expects from the people and what the people expects from the government. Right now, to deal with this integrity bill, it comes from the meaning of the word called the integer. In mathematical terms, it's called the whole. So we must look at this integrity bill in a holistic way to go forward. And I will say that this is a step that is in a good direction to protect our social, political, education, and economic development as a small and developing state here in the Caribbean. And we must understand that corruption in government has its history. I've never read a historical book where there is any type of political and economic integrity. It's always about political and economic corruption. And to deal with such a topic like this integrity bill, pertaining to all the aspects that is included in government contracts, government dealing with business and running government business, and dealing with the entire system of economics, because it's the main thing that really causes development in the country. The politics and economics of that nation that's been done by the people who are put in place to do that. And in the years that we have read in history, we have found out that politics is the art and science of government. And economics is the science of production and distribution of money and goods and services. But we have come to the place in the last administration, we have come to the place where we have been deprived, put in a disgraceful position in the last administration. And that's why we are here today, I believe, because 6 years ago, this bill was tabled, but I recognize it got the legs to leave the parliament to become a legal document in the public street. But now this is 2018, 6 years after, that we're going to try to make this bill a legislative bill so that we can have some form of protection. Because I recognize to pass a bill on morality is an imposition of a government. But for you to have morality is a supposition. So we are plagued with two things. An imposition, which is by legislative power, and a supposition, which is of your own power. And in this matter of integrity, you must have integrity in your private and personal life, and in your public and professional life, to be a good example of a good citizen in this country of Barbados. So my presentation today is from my heart, having a voice for the people of Barbados in respect to our leadership in the position of political and economic power. And I will understand that government is the head. We depend on government for decision making. We depend on government for policies, which is rooted in law, that we may govern our affairs and our social life. And that's why I was honored to receive this official invitation from the governor of Barbados under this present administration. And I felt good that I can speak at a level like this to the people of Barbados and to address this commission. Part of my recommendation for this commission is what I put together. I read the bill, I've been studying the bill, but there's certain things that I got my answer to in the previous meeting that was on the 27th of August. I got some of my answers there when it was first commenced, when I first was partaking in this presence. And now I have a couple of questions to the commission pertaining to who should be the members on this commission. Will these members be other standing or sitting members in government, or they shall be an entirely select body, the independent body, to deal with this commission as we go forward in passing this legislative bill. And another part of my point is dealing with the punishment that is being exercised by the bill. When it comes to fines, punitive measures, and mandatory sentences based on the offense that is taking place by whoever in public office. And we have to look at this as a serious situation in the governance of Barbados. We know we have a level of tolerance in corruption in Barbados that's tolerated by many and few. But this is a time in our history of political governance where we have found ourselves deprived of integrity, deprived of morality. Because when law and morality have a conflict, it left the citizens to have such an alternative, cruel decision to make. Whether they will maintain their moral behavior or have disrespect to the law when it comes to the
Mr. Hunt,
governance.
I don't actually want to interrupt you, but just so it would help us, if you could perhaps direct or focus a little bit more on the bill and any input into the bill, any suggestions you have to make the bill more effective, any concerns you have about the bill, those sort of things would actually help significantly. I don't want to stop you, but if you could just focus in that direction, it'd be a bit more useful for us.
Thank you. Well, I have a lot of concerns pertaining to this bill. And the main is an integrity bill. I want to make sure that the rule of law is the detection and protection of the people, according to this opening statement. It must promote all integrity by rule of law, if we choose that legislative mean, and it must be where we detect and investigate this bill when we see it in public life, because we got to understand what are we going after. I'm not a legal mind, I'm not an academic mind, but I want to direct it. Is this bill going to become, as someone said, a talk shop, or is just a futile exercise pertaining to this bill? And that's my concern. I want to see results with this bill. You the people who have formed such a commission with the legal authorities and powers that you have. My concern is to see results on a bill like this to regulate proper governance in Barbados. And I will understand that it is not easy to run a government and the people. Decisions have to be made, but it should be made in good faith. So I want the honesty of the leaders of the country based on the integrity bill, and make sure this bill is sharp enough on both sides and have a hook like a cane bill so it can hook and catch those who have committed an offense under this act. That's my heart. I'm speaking from my heart. And that is why I can always believe that we must go forward, and it seems that the Constitution and the rule of law is what we must adhere to and pay attention to. So I would like to direct the Commission on the real process of the rule of law in this bill. This bill has the power of the rule of law. This is not what we may come with our own mind. This is covered by the rule of law and the power of the law. So we must let the law be the law, and let this bill be a tool to protect us, the citizens of Barbados, and even yourself from the very results of disobeying the law or even breaking a cause and offense in this document. So I want to speak from my heart continually, as I believe that I love my nation of Barbados. So to you as a people, and as I said, intellectual and legal minds, I don't really want to detail a lot from this book, because this act here has already been drafted and crafted and constructed in your hearts and in your minds. There's little I can say to you that can really amend or change anything much in this document, because this has been constructed in your minds already. So I will understand that this is indeed a document that's put forth by legal and academic intellectual minds, to which you will have the final say on this document, and we will have to follow the procedures of this document in the end. So my concern is that we can go forward and we can maintain the civil governance under civil rights of democracy. And one of my concerns, I want to see persons charged when they violate this, the CRD, the civil rights of democracy. Some person have to be charged, reprimanded, and detained, confined, and fined. And I consider that the fact of the deterrent, this is one of the points I'm going to deal with now, using the deterrent against corruption. I think we need to change that word. This is my perspective. We cannot come to use a deterrent. We got to try to use a detergent, a cleansing agent. And I would recommend we use a detergent, a cleansing agent to clean this country from any type of corruption. Because it seems that deterrents don't work. You have to use a detergent, a cleaning agent. Let's do some industrial cleaning within the government of Barbados, for we have been tolerating this thing for too long. And I want the people of Barbados to understand that Barbados is all that we have as a nation. If we cannot sell what we have and leave Barbados, Barbados is all that we have. And we must protect that as a government and as a people and as we go forward in the governments of Barbados. And this document, I've studied it, and it's good in its written text, but we have to see the manifestation, the operation of a document like this, that the people of Barbados can have hope in believing that the writers and firmaries of law in Barbados have integrity and morality, to which without those things, we will be in conflict all the time with the law that governs us on a daily basis. So I want to thank the people of Barbados. I want to thank this commission that is go forward. And I would like to recommend that part of my documents I have here, I'll remember in my mind, is that no person or sitting or standing member should be a part of this commission. That's my recommendation. This shall be something like a separate body. Selected, that you who draft this document, give them the power to exercise this commission, to go after, because remember, the document is based on in public life. So this is my recommendation, have a private body full of the intellectual minds and legal minds to be commissioned and given the powers that's necessary to carry out this commission in the investigations of corruption in Barbados, even in the region, that we can work together and get Barbados on the right track going forward.
Mr. Hunt, I want to thank you for your contribution. I can just address some of the things that you asked very quickly. We've had discussion as to whether the bill is going to be a talk shop. It is not intended that this bill is going to be a talk shop. The reason we are here and going through this process is so that all people who feel that the bill is not as effective as it should be, or they want to suggest more teeth there, or they have constructive suggestions that we can take on board, we will take on board, because when the act is eventually passed, we expect that this act is going to govern and control those in public life. The other thing that you questioned, you had a concern as to whether any members of the commission will be sitting MPs or in government. No. The first schedule, so who can be members of the commission? For people who might not have been here last week or viewed online last week, I'll just assist you. The members of the commission shall consist of a chartered or certified accountant of 7 years standing appointed by the Governor General, a person who holds or has held the office of a judge in a superior court of record in any part of the Commonwealth appointed by the Governor General, and this is after consultation with the Prime Minister and the Leader of the Opposition, an attorney at law of, it was initially 10 years standing, but I think we've been pretty much unanimous in the last sitting that we're going to ask for that to be changed to 20 years standing, a member of the clergy appointed by the Governor General after consultation with the Prime Minister and Leader of the Opposition, a person appointed by the Governor General on the advice of the Prime Minister, and a person appointed by the Governor General on the advice of the Leader of the Opposition. There are no sitting MPs or members of the government on the commission, but it might actually help you if I actually read who is disqualified from holding membership on the commission. A person shall not be qualified to be appointed as a member of the commission where that person, A, is a member of the House of Assembly or the Senate, B, has at any time during the period of 3 years preceding the appointment been a public officer, C, has at any time during a period of 5 years preceding the appointment held office in any political party, or D, would otherwise be disqualified in accordance with Section 38 or 44 of the Constitution, as the case may be, to be a member of the House of Assembly or the Senate. So I think that should completely address that concern that you had. And the other thing I just want to clarify is you had stated that this bill was laid 6 years ago and is now only now coming on. This is a brand new piece of legislation. The other government, the former government, had purported to lay another piece of, it was passed, but not proclaimed. So this is a brand new 2018 piece of legislation that we are seeking and welcoming the input of the public and all sectors of Barbados in to make sure that when it eventually is fully debated and finally passed, that it's a bill by consensus effectively, not just consensus of the House, but consensus of Barbados. So I hope I have addressed your concerns.
Thank you very much.
Any members of the committee wish to engage Mr. Hunt further? There being none, Mr. Hunt, let me thank you very much for your very erudite presentation, and we look forward to your continued interest in the work of this committee.
Thank you.
Thank you, sir. You feel free to stay with us.
Thank you.
As an administrative matter, we have done a very quick caucus, and it is the will of the committee that all of these submissions be put online. So, Mr. Clark, if you can put that in place with all possible dispatch. And it is also the will of the committee that members in the gallery should not just decorate the precincts of Parliament, but that if they do wish, they can pass a written question to one of the marshals, and we'd be willing to offer it up to any of the people making presentations today. If you need note paper, you can get note paper from the marshals as well. Our next presentation will come from ICAB. Their representatives are Mr. Andrew Brathwaite and Mr. Reginald Farley. I have no indication as to which one of them or whether both of them will make presentations, but I think whoever speaks first, we will acknowledge as the person who will be presenting, and I anticipate that both would be available to take any questions from members of the committee or from the gallery. Gentlemen, the floor is yours. And you're reminded that we have your written presentation as well.
Thank you, Chair. I will be the one making the presentation on behalf of the Institute in my capacity as president. On behalf of the council and members of the, I don't know if were we properly introduced? I don't recall. Oh, I did.
I believe everybody knows who Mr. Farley is, so by default, I suspect that everybody knows that you're Mr. Brathwaite.
Everybody knows him, and my name is Andrew.
But your name is Andrew Brathwaite.
Brathwaite. On behalf of the council and members of the Institute of Chartered Accountants of Barbados, ICAB, let me start by expressing our gratitude to the Joint Select Committee for accepting our written submission and inviting us to make this oral presentation to expand on a number of our comments and add some color. ICAB is a proud member of IFAC, the International Federation of Accountants, which is a global umbrella organization for professional accountancy organizations. IFAC in recent years has drawn attention to an increasing public expectation that the profession should play a bigger role in enhancing governance and addressing fraud, corruption, money laundering, and other unethical practices. The fight against fraud and corruption has therefore been identified as one of the organization's core speaking out themes, and ICAB has followed suit. ICAB supports the view that the time is long overdue for integrity legislation to be introduced in Barbados, and we commend government for its speed in laying the Integrity in Public Life Bill in Parliament and for convening this select committee to examine the bill and accept public comments. It should in fact be a matter of some national embarrassment that of 140 countries that are signatory to the 2003 United Nations Convention Against Corruption, only Barbados and Syria have not yet ratified the convention by enacting the required legislation. It is worth pointing out, as well as was explained before, that while Barbados already has a comprehensive Prevention of Corruption Act based on the United Nations Convention, and which was passed by both houses of Parliament in 2012, unfortunately, this legislation was never proclaimed. The current bill improves on the 2012 Act in some respects, but a number of critical areas have been omitted, and we believe that it is vital that these be addressed in due course. Let me start with the subject of declarations of financial affairs. which must be filed every 2 years with the Integrity Commission to be established under the legislation. These declarations are to be filed by specified persons in public life and are a necessary feature. However, we would caution the committee and the commission that these declarations have been problematic in other Caribbean jurisdictions. In Jamaica, for example, of 224,000 declarations due for filing for the years 2003 to 2015, 85,000 or 35% remained outstanding in 2016. During 2015, however, only 93 delinquent public servants were reported to the Director of Public Prosecution for court action, and only 47 were brought before the court. Similarly, in Trinidad, at the end of 2016, the Commission had a backlog of 2,700 declarations to be examined and certified. Since the Commission only certified 1,700 declarations during 2016, it will clearly be challenging to clear the backlog while still examining and certifying current filings. During 2016, the Trinidad Commission published the names of 663 persons in public life who failed to file declarations during the period 2003 to 2014, accounting for 1,361 declarations. By the end of 2016, 130 of that number had filed 322 declarations after the names were published, so about 1/4 of the outstanding declarations. And these statistics are based on the most recently available annual reports of the commissions in Trinidad and Jamaica as published on their websites. The number of required filings in Barbados is likely to be significantly lower than in Trinidad and Jamaica, and ICAB is comfortable that the requirement to file the declarations every 2 years instead of annually will alleviate some of the challenges experienced in Trinidad and Jamaica without materially reducing the effectiveness of the measure. We are pleased as well that the legislation provides for publication in the official gazette and in the daily newspaper of the names of specified persons in public life who have failed to file declarations or furnish such particulars as requested. We propose, however, a few additional matters for the committee's consideration. One, the form of the Declaration of Financial Affairs should be published for public comment before the Joint Committee concludes its work. And the 2012 Act does have the form of the declaration, and similarly, the Turks and Caicos Ordinance on which this legislation is based includes the form of the declaration. Two, a detailed list of the specified persons in public life captured by the second schedule to the bill should be published well in advance of its enactment to remove any uncertainty about who is required to file. And in Trinidad, the Integrity Commission and the Attorney General were forced to seek guidance from the court on some matters of interpretation about who exactly was required to file. And in that 2005 judgment from the court, they also made a ruling that judges and magistrates were exempt from the requirement to file declarations and from the provisions of the relevant legislation. In Trinidad, the provisions are actually embedded in the Constitution, and the court found that there was a conflict between those provisions and other requirements in the Constitution that apply to judges and magistrates. Three, the requirement in Clause 29 for the accuracy of the declarations to be verified or determined should be carefully considered and refined to give a more precise indication of the extent of the verification which is to be performed. Clause 31(5), which requires the Commission to provide a certificate of compliance upon being satisfied that a declaration has been, quote unquote, fully made, may also be problematic given the challenge in verifying possible omissions. 4, the Commission should be given the discretion to determine, using a risk-based approach, which declarations to examine in detail and when to do so. 5, following the 6-month extension which the Commission may grant under Clause 25(3), it should be empowered to make an ex parte application to the High Court for an order directing any specified person in public life who is still delinquent in filing to comply with the legislation on automatic penalty of a specific file or jail sentence. And this is actually a provision in the Trinidad legislation which was introduced after the Commission lobbied to that effect. To be clear, we are not persuaded that the detailed examination and verification of declarations of financial affairs will be a productive use of the resources of the Integrity Commission. We are, however, open to any empirical evidence to the contrary and would strongly advise the Commission, once it has been set up, to consult with other integrity commissions in the region and beyond and seek out best practice in this area at the earliest opportunity. There are a number of other key areas where we think the legislation could be strengthened. We believe that the Auditor General should be included as an ex officio member of the Integrity Commission to facilitate the Commission's function under clauses 401F and G to examine and advise on practices and procedures of public bodies. This is actually the practice in Jamaica and would enable sharing of information between the two offices, a more timely follow-up of irregularities and concern discovered by the Auditor General during the course of his work. Fortunately, the bill already makes provision for agreements and exchange of information with law enforcement agencies, including the local and foreign financial intelligence units. Our view is that this will allow for more targeted investigation of potential corruption as compared to the broader approach of examining declarations. The Commission should also be given the express power to establish a hotline to receive anonymous tips from the public, including from public sector employees. According to the Association of Certified Fraud Examiners, of the corruption cases reported by their members for 2017, 50% were discovered by tips. And the association has consistently reported over the years that tips are the most common method by which fraud and corruption are detected. While we are happy that the bill includes provisions for the protection of whistleblowers, we believe that individuals with information about possible corruption will likely be reluctant to identify themselves and appear before the Commission or in a court of law to offer evidence. We recommend furthermore that the provisions of the Integrity in Public Life Bill be compared to the requirements and recommendations of the 2003 UN Convention Against Corruption, as there are a number of gaps that need to be addressed. For instance, based on the convention and best practice in other jurisdictions, consideration should be given to contractor general or similar legislation dealing with public procurement and divestment of public property, as these have proven to be fertile areas of corruption, campaign finance legislation, freedom of information legislation, for which a bill was circulated in 2008 but never laid in Parliament, and measures to discourage and penalize corruption involving the private sector. These are all critical elements of an effective anti-corruption regime, some of which, in fact, are included in the 2012 Prevention of Corruption Act. We would also at this time remind the committee that International Anti-Corruption Day, sponsored by the United Nations Office on Drugs and Crime, is marked each year on December 9th. We intend to write very shortly to you, Chair, in your capacity as Attorney General, to urge that this day be officially recognized in Barbados. Finally, we would like to express our gratitude to the drafters of the legislation for making provision in the first schedule for one member of the Integrity Commission to be appointed by the Governor General after consultation with, quote, anybody which in his opinion represents chartered or certified accountants in Barbados, end of quote. We hope, though, that it would not be considered improper of us to suggest that this language be amended to make specific reference to the Institute of Chartered Accountants of Barbados as the body designated by statute to regulate and represent the interests of chartered accountants in this country. as has been done in the case of the Barbados Bar Association. I only said that because I saw the smiles. And I use the pronoun his in relation to the Governor General only because that is the language in the bill itself, and not to draw attention to the fact that the gentleman currently acting in the post is a member of the Institute, of whom we are extremely proud, and was in fact our very first president. I thank you for your attention, and my colleague and I would be happy to discuss our submission and answer any questions.
Thank you very much, Mr. Brathwaite. The gentlemen are now available to be engaged by the committee.
Thank you very much to the representatives of ICAB, Mr. Brathwaite and Mr. Farley, for a comprehensive written submission, which we've had the time to go through in some detail, and for an oral presentation which further augmented the solid recommendations which are contained in your written submission. I think that you have added value to the discussion by linking it to the umbrella international context within which many of these measures are contemplated. Indeed, we're talking not only about the UN Convention on Corruption, but of course here in the Americas, the Inter-American Convention on Corruption, where we remain the only country in the hemisphere not to have ratified that instrument. So I have a couple of questions specific to your comments, your recommendations on matters which are not yet covered in the legislation, and I wanted to speak to it more widely within the context of other complementary items of legislation which may need to augment the provisions that are currently being contemplated here. So let's go. You say, for instance, that the convention, the UN Convention, this is, speaks to four things. Four of those things which were indeed referenced in the previous anti-corruption legislation which was passed and not proclaimed, but are not contained within this legislation. They speak, first of all, to systems of procurement based on transparency. What would be the specific recommendations that you would want to make to have incorporated into this bill with regard to procurement, and if not necessarily within this bill, if there are amendments that need to be made to other items of legislation? The same thing applies also to the measures to enhance transparency in the funding of political campaigns and political candidates. That is another component which is not contemplated in this current bill, but was in a previous legislation. What would be your recommendations? And then, of course, the relationship to the private sector. The final point which you have made in this section relates to sharing of data. You're talking here essentially about open data, and there has been quite a lot of discussion in the public space in the last few months about open data, freedom of information legislation, and those kinds of things. Are there specific recommendations that you want to make at this time on those items? Thank you very much, Chair.
Thank you. The specific recommendation that we are making broadly is that a comparison be done of the requirements of the UN Convention, because the articles in the convention itself are very comprehensive as to what is expected that you would see in the legislation, or recommended that you would see in the legislation. We are not necessarily suggesting that those provisions be included in this particular legislation, but they need to be addressed in some form or fashion. So if, for example, across the region, we have examples of contractor general legislation. Jamaica in particular has had a lot of experience with this, and arguably a lot of success with this, and they've certainly identified areas where the contractor general legislation needs to be enhanced. In fact, in 2017, Jamaica passed new integrity legislation that combines the Integrity Commission with the Office of the Contractor General and another parliamentary body that was dealing with corruption. So they've pulled everything into a single body and given them expanded powers, including the powers to prosecute where there's suspected corruption. The UN Convention also is accompanied by detailed implementation guidance. So again, I guess we have not come necessarily with specifics as to what that guidance requires, but just to say there is very detailed guidance on the provisions that are best practice to be included in relevant legislation.
Bradford, thank you. Good afternoon. Reference to Section 29 of the bill. The commission or the Governor General, as the case may be, shall receive, examine, and retain all declarations and documents. Your organization is suggesting that some discretion should be given, that the commission may determine which declarations it would choose to examine and when to do so using a risk-based approach. Are you not, if you go that route, in your view, exposing the commission to the jeopardy of being accused of discriminatory behavior based on some partisan or other consideration?
Thank you. Yes, that is a possibility. And when we surveyed our members on that particular question, some of them did point out exactly that. The overriding concern, though, is one, whether the commission will be able to adequately handle the volume of declarations, and B, whether there is reasonable value in having the commission attempt to do detailed examinations and verifications of file declarations. So that is partly on the assumption that persons involved in corruption are more likely not to disclose ill-gotten gains than to disclose them in the declaration and risk detection upon examination. And we don't have the empirical evidence to support that, but we're suggesting that the commission, one of the first things the commission should do is investigate the efficacy of doing these detailed examinations of the declarations.
Give the floor to Minister Jordan, but before I do that, Mr. Jordan, I just wondered though whether ICAP had taken into account the potential numbers of individuals who might be captured in our second schedule. Just taking members of the House of Assembly, that's 30 at the moment. Members of the Senate, that's 21. Members of the Cabinet are drawn from the upper and lower house, so that doesn't really count. Permanent secretaries, heads of department, being that I really can't imagine that we'll be dealing with more than perhaps 250 people who would have to file declarations. Now, that number may go up or down, but certainly in the context of Trinidad and Jamaica, for Jamaica to have 85,000 declarations outstanding, and I'm sure that's cumulative, but I'm just thinking that there might be a significant difference in numbers between the amount of declarations that need to be examined, and it might be better to err on the side of doing all if the number is manageable. But I'll hand the floor to Mr. Jordan.
Thank you, Chair. Mr. Brathwaite, I would add my thanks to, my appreciation to you and ICAP for the submission. I just had one small question. You had mentioned including the Auditor General as a member of the commission. And I had two questions came to my mind. One had to do with his role as a public officer and the likelihood, well, he being, either whoever it is, in terms of gender, but that person being likely an expert witness to use that phrase, in some investigation, would that person being a member of the commission compromise the role that we expect an Auditor General to execute? For example, in our current setup, before Public Accounts Committee. So that was my question as to your rationale, and did you take that possibility into consideration?
Thank you. It is a good question. What I would say, though, is that the practice of having the Auditor General as a member of the Commission is already done in Jamaica. So Jamaica has done it for many years. And as I mentioned before, Jamaica has now formed a new anti-corruption body, and they've continued to include the Auditor General as a member of that body. But I would think we would need to, or we could easily speak to the Jamaica Commission or persons in Jamaica who might have more detailed information and get a response to, or get an idea of what the complications are that might arise and how they might arise. But the fact that Jamaica has continued to do it under their new setup suggests that it has not been overly problematic.
With your leave, Chair, if I can just revert to Bishop Anthony's question. The matter of resource allocation was one of the matters we had discussed in relation to using, giving the Commission the discretion to use a risk-based approach concerning its examination, because we have the situation where for many years now, the Auditor General, for example, has not had the number of posts filled to be able to do the audits he requires. And if you have approximately 250 of these filings every 2 years, then depending on what level of examination, verification you're seeking to do, that dictates a level of resources which, quite frankly, may not necessarily be affordable. One of the discussions does not matter for the legislation, but more for the functioning of the Commission. We also discussed the matter of the manner of filing, just what is declared, how it is declared, including the matter of electronic filings, because electronic filings using interactive technology allows for some of that preliminary processing to be done electronically. If it is all done in paper or just in static electronic format, then it requires people to enter into a system and to do other forms of processing. So that we should, well, not the legislators, but the Commission, in terms of its operations, should use relevant available technology to make the analysis of the information presented easy. And we've also suggested in our written submission that simplifying how the information is presented makes for more willing filers. Realistically, filing anything is a burden. And to the extent that we can keep it simple, encourage complaints, and that we can use electronic stuff, that helps. The other point on the electronic filing is that one of the important aspects of the analysis done by commissions looking into corruption and so on is time series analysis. You're not analyzing just this year's filing. You're looking at last year, the year before, and that becomes a lot easier with appropriate underlying electronics. So as part of the matter for the committee, we strongly recommend that we strongly recommend the use of appropriate interactive technology, as well as the provision of adequate human resources. And finally, Chair, we also discussed, there was one of the recommendations related to investigator. In this matter, or in these matters, when we think of investigators, we tend to think of criminal legal types to investigate on that basis. But really and truly, the resources of this commission, in addition to legal, we would need to have adequate accounting, finance personnel to really understand exactly what is presented and to do the appropriate analysis. But those are matters really we didn't speak to because those are more for the functioning of the commission post the passage and proclamation of the legislation. But there were some of the inputs into the question or the debate we had around the matter raised by Bishop Atherley.
Thanks, Chairman. I wanted to ask a question about election campaign financing, but I'm going to ask that after I make my comment. You suggested that the Auditor General should be a part of the commission. I want you to suggest to us how is that going to be possible when the Auditor General is going to be required to audit the commission itself. You can't ask an auditor to audit himself. So what would be, how would you get that done in the legislation? How would you get that be operational? You know, because the Auditor General, if you look at Section 7 of the Act, the Auditor General must audit the commission itself. So how are we going to effect your suggestion?
Agreed. So our suggestion is that the bill be amended to provide for private auditors to audit the commission. We had actually included that as a recommendation when we commented on the prevention of corruption, the 2010 Prevention of Corruption bill, which was passed. But in essence, a private firm would have to audit the commission, and there are already private firms auditing similar bodies.
Okay, thank you. I just wanted to, because you know that had me a bit confused there. You spoke to election campaign financing, and what other measures that currently exist would you suggest? Because to my mind, our problem is not election campaign finance as such. I mean, rules to regulate it. We have more than enough rules. Our problem is enforcement. For instance, a candidate shouldn't spend more than $10 per elector. So if you have 6,000 people in your constituency, you can't spend more than $10,000. The person, I mean, $60,000, $10 by 60,000, you see what I mean? Also, you have a situation where persons claim that they give monies to political parties to help the campaigns, and I believe that they do. But the law says that these people must declare it. So the candidate who receives that money and the person who gave the money must make a declaration. I have never seen one. As a matter of fact, last time I went to the last election, not this current one, those returns are not out yet. I went to the registration department where they are stored, and I paid for copies. Mind you, they're just cheap. You get $3 to get one. And I went through them, and most of the information required by law is not there. So it is not, I don't think it is the regulations that you need. It is enforcement. The Electoral Boundaries Commission, they collect the documents, and whatever candidate says he spent. I saw a candidate in the last election who didn't have a telephone. You know, I doubt that. You know, but according to his declaration, he didn't have a telephone, he didn't have an office, he didn't have any flyers. You know, he didn't have any advertising material. And that was allowed to pass. So I'm saying we have the legislation. No, he lost this time around. He didn't lose that time. So it is not, I don't think we are speaking to the legislation. We have the legislation. It is the enforcement of the legislation that is not happening. And I suggest what we might be thinking, that we might take that regulatory power from the Electoral and Boundaries Commission, as opposed to keeping it in the hands of people who are appointed by the politicians. Like, for instance, the Chief Electoral Officer will not become Chief Electoral Officer unless the Prime Minister says so. You have now a duty, you know, and you might have to exercise that duty against the same Prime Minister. You're not liable to do it. So I think more, I don't know if you would agree, that that duty should be taken away from the public officers and given to the commission. I think that might be more feasible, and I want to suggest that, but I want to know if I got support.
Thank you. We share some of your concerns, and we agree that the effectiveness of the enforcement would be enhanced by bringing it under the scope or within the scope of the commission. And I believe that when Sir David Simmons was here, he spoke at some length to the success that they have seen in Turks and Caicos, where the regulation campaign finance has been brought under the Turks and Caicos Integrity Commission. And apart from that, in terms of strengthening the current legislative framework, the Turks and Caicos legislation and the UN Convention speak to financing of political parties and not just candidates in elections. So we think that that would certainly enhance the campaign finance regime if we had additional regulations relating to funding of political parties. So restrictions on the fundings and transparency in the funding of political parties. And in the Turks and Caicos, there's a separate ordinance that deals specifically with that.
Thorne has the floor.
Thank you. Thank you very much, Chair. Mr. Brathwaite, like my colleagues, Minister Jordan and Senator Franklin, I had also placed an asterisk next to the issue of Auditor General. And I'm disturbed by the proposal, and I'm sorry to use such strong language, but I am. He speaks as an accountant, I speak only as a lawyer. And the term I would use is conflict of interest. The Auditor General is actually a head of department. Caswell, is he? Yes. He's a head of department, and therefore he is himself subject to the scrutiny of the Commission in that capacity. So that there could be some severe conflict of interest in relation to this proposal. So I would encourage the association to revisit that proposal. If you say the Auditor General, there's nothing to stop you from saying the Commissioner of Police, who sits critically when it comes to investigation of corruption. So you can extend the list, but what the list should not do, the list should not elevate persons above the scrutiny that is intended over the entire public service. And I'd like to invite you to revisit that. And I'd also like to invite you to consider that even if you remove the Auditor General from auditing the department itself, the Commission itself, even that proposal, and you elevate him from that, put him on the Commission, you have put him into fairly rarefied air. In a sense, can he investigate himself? If one of the officers in his department is problematic, where does he stand? That's why I use the term conflict of interest. So quite gently, I'd like to suggest that the association revisit that proposal. And accept this not by way of criticism, but merely observation that you've done a very succinct paper, and that is commendable. But some of the proposals are really operational as opposed to statutory. Not everything goes into a statute, but I'm sure the Commission will accept, like the hotline, for example, you wouldn't put that in a statute, but I'm sure that when the Commission comes to life, it will be encouraged to look at your paper and consider some of the meritorious, and I do say they're meritorious, a lot of the meritorious proposals that have been made in terms of the day-to-day operation of the Commission. But the main point, I would want to resist the elevation of the Auditor General onto the Commission because he becomes exempted himself from investigation. Thank you very much.
Thank you, Chair. I want to go back to a point that you made earlier, and I want to contextualize it within the UN Convention on Corruption. You made a recommendation that there needed to be measures to prevent corruption involving the private sector and to provide effective, proportionate, and dissuasive civil, administrative, or criminal penalties for failure to comply with such measures. So in the context of the Convention on Corruption, it raises issues relating to things like the recovery of assets, requiring financial institutions to report, to verify identity of customers and those kinds of things. Within the actual draft of the bill, what would you recommend would be some of the asset recovery measures which don't currently exist in the draft as it stands here? From an accounting perspective, obviously, from a financial institution's perspective.
Thank you. I don't know if I can speak to it from an accounting perspective, and I certainly cannot respond in detail, but what I would say is that there is a section in the 2012 Prevention of Corruption Act that deals specifically with those measures. So we would need simply to refer to those, and those are based on the requirements in the convention, which unfortunately I don't have to hand. So there are detailed provisions in the convention, and those have been replicated in the 2012 Act. Sorry, and you also spoke about the private sector. So again, those are captured in the 2012 Act, which makes, includes offenses related to, for example, fraudulent financial reporting, and imposes stiff penalties on chief executive officers of private sector enterprises that are found guilty of bribery or other corrupt acts.
Mr. Brathwaite, I want to thank you for what was an entirely thorough presentation. I do note that the oral presentation contained a little bit more than what was in the initial comments that you submitted to us. So just for completeness, if you can actually, I don't know whether you've written, if you can submit those to the committee so that we don't miss anything that you would have said. And the other thing is, unlike Mr. Thorne, I won't ask you to rethink or withdraw your suggestion. I will simply say we will note it, and eventually the commission will actually make the decision as to what goes into or make recommendations as to what goes into legislation. All views will be considered, because I'm sure there might be some, when the commission sits to debate it among themselves, who actually do support the Auditor General. But I just want to thank you for what was an exceedingly thorough presentation. And I also want to thank ICAB for taking the time to put it down. Your submissions, I believe, are going to help us significantly. Thank you.
Minister Tate, or, sorry, the Chief Parliamentary Counsel acting, Ms. Williams.
I just wanted to make a point of clarification in relation to the supporting legislation that was mentioned, public procurement, freedom of information, recovery of assets. From a legislative point of view, those things will not be placed within this bill, but they would be the subject of a separate bill. So for example, public procurement, CARICOM is presently dealing with a public procurement bill, and we have been working with them for a considerable period of time on a bill, and it is at an advanced stage. And similarly with the other supporting pieces of legislation which will go towards the entire legislative framework and regime.
Thank you very much for that clarification. Ms. Cummings? Senator Cummings?
Thank you, Chair. I think that's an important clarification. I think many of us, from our perspectives, are familiar with much of that work, but for the purpose of the public watching online, some of the elaboration is really important. So when you follow the social media discussion, a lot of these issues are being asked, and so it's important from our perspective to raise the questions, get the answers so that the public has the answers as well. So your clarification is greatly appreciated.
And just to say, Chair, that we fully support it, and that's our perspective as well. What we sought to do was to frame our presentation within the context of an ecosystem for the prevention of corruption, some of which will be in this bill. But this bill, even though it carries the grand title of integrity in public life, cannot do it on its own. And we're just making the point that whilst we're doing this, let us remember to take a look at all of the other legislation. Some already exist, some which doesn't, to make sure that we can go through a checklist, match against the UN Convention or other standard, and make sure that we cover it all.
Thank you very much. Mr. Brathwaite, in as much as I'm going to allow you to wrap up, let me just put one question to you. Our bill also has a name and shame provision. That is, if you don't file, that we are prepared and will undoubtedly publish in the Gazette and the newspaper the names of people who are in default. And you are correct, a similar thing happens in Trinidad and I believe Jamaica. I cannot say, though, that I have any anecdotal evidence as to whether that actually works. The only time Bajans respond about anything in the paper is when you're knocking down their house or where the bank says that you have money, but you haven't come for it in the last 6 years. And I'm just wondering if there's any anecdotal evidence that that kind of approach has been able to encourage, if not compel, people in public life in those jurisdictions to publish. And the other thing, of course, is I have a particular view as Attorney General that we really shouldn't be locking up people for everything that they do. And I think coming over from what you said, you seem to be encouraging a situation where as long as there's a name, as long as you don't file, that you should be summarily sent as an overnight visitor to Her Majesty's Prison Dodds. And I don't know if that is necessarily the approach that we want to get, that where we end up criminalizing people. But you can address those in your final comments, after which we will hear Integrity Barbados. Oh, I have to give precedence to the Leader of the Opposition, more or less.
I apologize for the late intervention, Mr. Chair, but I wanted to really get in this question before Mr. Farley left his chair. Do we capture members of the diplomatic corps or consular officials and all of these people in this thing? Is the diplomatic corps captured in this? You don't have to answer that.
I'm sure our senators in the opposition, we are lawyers too, but we got to file. And poor me, I don't have anything to file.
Members of the diplomatic corps are not treated as subject to many of our laws, so we let that one pass. Mr. Brathwaite, your final comment?
Thank you, Chair. I'll try and capture all of your questions, but I'm sure Mr. Farley will jump in if I miss anything. On the question about penalties and the appearance that we are suggesting there should be a rush to jail people who don't file, that is not the case. We are simply saying that based on the experience of other jurisdictions, so Trinidad, I believe, for example, started out without that provision in the legislation that allows them to publish the names, speaking under correction. They then moved to that position, and unfortunately, I only had the data up to 2016, where they had just started publishing the names of defaulters. So you would see that it went back to 2003. By the end of 2016, which is the year when the names were published, 25% of the defaulters had filed, the ones whose names were published. So we would need to look at what happened after that. So what happened in 2017? Did they bring the number of defaulters down significantly following the publication? Part of the issue was that the commission had no power where the filers were delinquent to enforce any penalty. The matter had to be brought to court. So what they asked for was the power to make an ex parte application so that the court could order the defaulters to file. The penalty for non-filing in that instance would then be at the discretion of the court, presumably. I wanted to say as well that I made references to the 2012 Prevention of Corruption Act and how that was based on the UN Convention. However, I was not attempting to say that that act is perfect. There was a similar process when that bill was published. So there was a select committee of both houses of parliament. ICAB on that occasion as well submitted recommendations for amendments, and we also appeared before that joint select committee. None of those amendments were made. Fortuitously, some of the things that we recommended have been captured in this bill, but it is clear that the intention is that some of the things that are omitted will be included in other pieces of legislation, and we are entirely comfortable with that. Did I miss anything? So thank you very much, Chair, again, for allowing us the opportunity to be here. The Institute is available to the Commission to lend assistance in any manner that the Commission sees fit.
Thank you, Messrs. Brathwaite and Farley. And on behalf of the committee, we'd like, and members of the Gary would like to congratulate the ambassador on his recent appointment. I take it that at some point in time soon, sorry, High Commissioner. High Commissioner, and I imagine that ICAB will miss you.
ICAB will certainly miss him.
And many people will.
And thank you very much, Chair and Commissioner.
We want to thank you for joining us, and you're invited to stay. We shall now welcome Integrity Group Barbados. Money Watch, Chair. Ralph? We'll resume as soon as the members of the committee take their seats. A bit of musical chairs. Yeah. Now you can start. Thank you very much. Let me welcome Integrity Group Barbados. Let me especially welcome Beverly Lady Waldron. I'm delighted that you would join us. You are more than a fitting substitute for Mr. Shaw. In fact, I'm happier to see you than him. And with you, Lady Waldron, is Ms. Alicia Archer and Mr. Devon Bruce. I am not aware as to who will make your presentation. Ms. Archer,
Yes, I will be the one making the presentation.
you have the floor.
Yes, thank you. Chairman and members of the committee, ladies and gentlemen, given the time constraints, we don't propose to rehash the provisions as discussed in our written submissions, which were submitted to the committee on the 23rd of August 2018. However, we wish to use this opportunity to essentially underline and italicize a number of key issues that we think bear heavily on the effectiveness of the legislation before us. In order of importance, we consider those issues to be: 1, the whistleblower provisions; 2, the deterrent effect that the legislation needs to have, especially as it relates to the penalty provisions; 3, the composition of the second schedule, or in other words, those who fall to be considered as persons in public life; 4, the absence of provisions governing the financing of political parties; and 5, the funding of the work of the Commission. If time allows, we also propose to speak briefly to the need for other pieces of legislation to bolster the fight against corruption. Now, to begin, one gets the impression from the public discourse so far that corruption offenses are being viewed as a breach of some sort of moral code, or akin to the offense of theft, which, relatively speaking, in the hierarchy of criminal offenses falls somewhere in the middle. However, if we consider that with corruption offenses, the state is actually the victim, and we consider those offenses to be little better than treasonous, then with that mindset going forward, we can accord to the exercise the level of seriousness that it merits. In that context, the persons who bring such treachery to light have to be the single most important cog in the mechanism of the entire mechanism of the anti-corruption framework. If people are operating in the shadows and behind closed doors, it is necessary for someone who is actually privy to the secret to bring it into the light. In Barbados, we say that it takes 2 hands to clap. In other words, public officials do not corrupt themselves, they do not bribe themselves, and therefore there must clearly be a private sector counterpart who is the left hand if the public official is the right hand. There is therefore no good reason that we have found for the limiting of the whistleblower provisions to public officials only. Frankly, given the convoluted nature of the procedure to get someone out of the public service, a private sector counterpart is far more at risk of victimization and so on than a public official. The provisions as currently drafted provide no external motivation, whether through reward or otherwise, for anyone to put their mortgage or their plane trips to Miami on the line in order to bring this information to light. If there is no information, what is there to be investigated? If there is no investigation, what is there to be prosecuted? If there is no prosecution, there can be no deterrence. And therefore, people will feel free to continue doing as they like, secure in the knowledge that the legislation is ineffective. In that vein, we submit that 1, the whistleblower provisions need to be extended to any and all persons, however they may come by the information, and not simply be limited to the very narrow class known as public officials. 2, it needs to be emphasized that Section 68(3) should be completely excised from any iteration of this act. For the record, Section 68, subsection 3, reads that a disclosure is not a protected disclosure where the public official commits an offense by making the disclosure or discloses privileged material or information disclosed to him in the course of obtaining legal advice. Now, especially paragraph A can be used as a weapon to wholly undermine whatever protections are afforded by the legislation by simply creating subsequent legislation indicating that it is now an offense to disclose X or it is now an offense to disclose Y. 3, what should be a very simple proposition we consider to have been made unnecessarily complicated. And the provisions as drafted appear to present a barrier to the actual disclosure of the information that is necessary for the process to be gone through. The average Barbadian tends to consult their friend in the supermarket or rum shop. They're not going to pay a lawyer to find out whether their, quote, employer is a person who is appointed under the hand of the Governor General or pursuant to some enactment. So that even if you work for the Crown, how exactly do you identify who your employer is? So that the term employer is nowhere defined in the legislation. It is not outlined how one identifies said employer in the legislation, so that we are either left open to litigation, which we would really try to avoid, or it is left to interpretation. To facilitate disclosure by whistleblowers or other concerned citizens, we think that simplicity needs to be key, so that the disclosure should really be made directly to the Commission and not to the multiplicity of persons outlined in several different sections in the Act. 4, even if they make it through all of the obstacles that are presented, what happens to these people and their families? Where large sums of money and status are at stake, these people are at risk. What needs to be expanded on in as clear a fashion as possible is the protection to be afforded to whistleblowers and their families. Do we provide explicitly for in-camera evidence? Do we punish the victimization or the intimidation of a whistleblower's spouse or children for the purpose of getting them to recant? Should the burden of proof not fall on the employer or the person in authority to establish that their attack was not motivated by disclosure, as opposed to the Crown or the state having to prove that it was? 5, consideration should also be given to other anti-corruption models which provide incentives for disclosure. For example, a percentage of forfeited property on a successful prosecution, plea bargaining for a reduction in sentence if you happen to be complicit. This brings us to issue number 2, or the question of deterrence and penalties. Now, the point in this case may be best made by way of an illustration. If on a $300 million contract, my fee for awarding that contract, and fee in quotation marks, is for awarding that contract to X is $10 million. Is it not reasonable to assume that I may be quite happy to write a check to the Treasury for the $15,000 fine, or even the $500,000 fine, possibly even take a 2-year state-sponsored all-inclusive vacation in the best parish in the island, and then come back out and spend my other $9.5 million less legal fees? So that the penalties must make corruption unprofitable. If not, we're wasting our time. We would submit that in this case, and when we say this case, we mean the real corruption offenses. We're not talking about failing to turn up to the hearings and so on. But in the real corruption offenses, we are suggesting that a formulaic approach might be better than a fixed penalty approach. And Barbados is no stranger to a formulaic calculation for penalties. For instance, drug offenses, the penalties can range up to 2 times the value of the drugs. So that we are also suggesting that the sentencing tribunal, or a sentencing tribunal, should have an entire suite of punishments at its disposal to tailor it to the particular circumstance. And immediate forfeiture of any ill-gotten gains, as well as disqualification from holding certain positions, such as statutory boards or public corporations, need to be standard punishments. If you stand to lose more than you've actually gained, we would already weed out the opportunistic person. And then, coupled with proper whistleblower protections, we would then be left to focus on those who are hell-bent on doing what they feel like doing anyhow. This feeds into our 3rd point, that the second schedule needs to err on the side of being comprehensive, as opposed to, from the get-go, excluding large classes of persons who fall squarely within the definition of being politically exposed and who are prime candidates for corruption, whether now or in the future. Where are the references to the Commissioner of Police and officers of senior rank? Where are the references to customs officers and immigration officers, which by virtue of the nature of their jobs, they are perfectly primed for corruption approaches. Where are the judges? And yes, there is the bandying about of the decision from the Trinidad and Tobago court. But one, that requires an examination and a comparison of our constitution versus the Constitution of Trinidad and Tobago. The decision itself needs to be examined minutely and not just say that because Trinidad's courts have ruled that we therefore take it for granted. We have courts here, we have the CCJ, we have any number of avenues to determine if in a Barbadian context, judges should also be excluded. Then the government also has a number of limited liability companies incorporated under the provisions of the Companies Act, which are different from statutory corporations. Those are not captured in the legislation as it is currently drafted. They also are a number of private corporations, essentially, where the government has a significant shareholding. Those are also not covered by the legislation. And as well, since those are not covered, the boards and the executive officers of those institutions are not captured in the second schedule, and we would suggest that they should be. So that essentially what we're trying to do is to facilitate discovery in order to root out corruption, so that the net needs to be as wide as possible, so that if you catch a small fish, he may lead to a bigger fish, as opposed to just focusing on the bigger fish, which may be a little harder to unravel. This takes us to the question of political parties, which are essentially unincorporated associations set up for the express purpose of securing the election to office of a number of the persons listed in the second schedule, who certainly in a Barbadian context, in turn appoint other persons mentioned in the said second schedule, and usually from among the ranks of the same party. The question, therefore, is, can I not simply make a donation to secure my contract directly to the party, as opposed to an individual who must file a declaration? The party can then build up its war chest, and eventually, when the limitation periods, which we consider to be quite short, 2 years and so on, when the limitation periods have passed, then we can distribute with impunity. So that the exclusion of political parties and the executives of those parties from the reporting requirements in parts 4 and 5 of the bill constitute a rather large loophole which allows for circumvention of the provisions. The integrity legislation and the regulation of political party financing go hand in glove. Listening to previous questions and comments from Senator Franklin, he'd indicated that we have a problem with enforcement as opposed to a problem with legislative provision for political party financing. The legislation that we currently have, which is the Election Offenses and Controversies Act, the Representation of the People Act, deals specifically with the election period, so that it does not cover my $100,000 gift to a political party after an election has passed, so that essentially I have 4 years and some in which to make all the donations that I wish to make in order to secure whatever I wish to secure. I don't have to wait until an election is called to donate money to the party, so that we really effectively do not have legislative provision for political party financing currently. Finally, we also need to facilitate the ongoing work of the Commission itself, but it will always be inherently problematic where the monetary support is to be voted on by Parliament, so that the chief people who are most at risk of being approached for the purposes of corruption are the people who are tasked with deciding on an ad hoc basis how much money the Commission is supposed to get to carry out its functions. I can simply starve you of resources, bog you down, have all the backlog, and therefore continue to do what I wish to do with impunity. So that we are not acting in a vacuum. We live in the world. There are, 100 and something odd countries in the world that we can examine their legislation and see that there are different funding models. Even close to home, the CCJ is funded by a trust set up I mean, obviously resources and so on will dictate whether that makes sense. But going forward, we would suggest that the concept of the financing of the commission should be an ongoing exercise, essentially, so that it should be subject of a future amendment, given that the time constraints of having to try this, to get this legislation passed, does not necessarily provide currently for a time span where we can examine several other models and decide on a better one. In closing, we wish to state that the bill that is currently under discussion cannot be a standalone piece of legislation. It must, in the short term, be followed with freedom of information legislation, enforceable procurement legislation, as well as an examination of our current defamation laws, so that essentially we would hope that when this act is passed, there is not a lag of another decade between that and the means to allow persons to unearth the information that allows this act to function as it should. Those essentially conclude our oral submissions, and we are happy to respond to any questions that the committee may have.
Thank you very much, Ms. Archer. Members of the committee are now available to engage.
Chairman, thank you. I find it very difficult to engage you and disagree with you, anything that you had to say. You had a very comprehensive presentation. A lot of what you said is very desirable. And, but there's only one thing I want to touch on. It is the area where you spoke about financing political parties for the outside the election period. I want suggestions as opposed, because I know that is a problem. You can give it, you can do that and put the money down for a while, and then eventually they have a lot of money. Usually political parties are starved until campaign time. I know because I used to be a member of a political party, and you couldn't pay staff. But at election time, they're washed in cash. But with this bill in place, or this, if then this bill becomes an act, but this act in place, your suggestion could apply. What would be your suggestion to counter that?
Well, on page 8 of our, well, thank you for your compliments. And on page 8 of the written submissions, we listed as ancillary concerns ways, or at least an initial suggestion as to how we could make political financing more transparent. Reference had been made to the United Kingdom Political Parties Elections and Referendums Act 2000, which arose out of a Neil committee that had considered how to make politics in general more transparent and to provide not only for money spent during the election, but for the entire arena of political financing. That act places certain responsibilities, for instance, on the equivalent of the general secretary of the party, the treasurer, and so on. It's very detailed, so that if you have a look at that, I didn't bring it with me, so that if you have a look at that, it gives...
It is called?
The United Kingdom Political Parties Elections and Referendums Act 2000, page 8, under ancillary concerns.
Thanks.
Ms. Archer, I sat here eagerly awaiting your presentation. I just say, for the purpose of full transparency, I've known Ms. Archer for a very, very long time, and I'm singularly impressed by her all the time. With respect to the limitation period, I think we've pretty much accepted based on the presentations last week and discussions that we've had that what you call the limitation period of 2 years after is too short. So rest assured that unless something really untoward happens, the eventual period that you're going to see is going to be significantly longer than that. I think the period you're looking at mooting is 5 years. Also, I fully agree with you in respect to forfeiture. It makes sense that anything that you've gained illegally, you should lose, and your penalty should be on top of that. So you get no complaints there. Your suggestion to widen the net to catch the small fish because the small fish lead to the big fish, I'll tell you, it poses a problem because when the legislation was initially being drafted and we had to consider the people who would be caught or subject to the provisions of the legislation, the very real concern was raised that if we extend it to all statutory boards and just expand it to catch these small fish, then we would actually likely run into a problem where no one wants to sit on boards or no one wants to participate at a small level in public life. So those are some of the concerns that inform the drafting and the selection of people. I take your point, however, and as I said, at the end of the day, the committee will look and consider all of the recommendations, and where we can facilitate them, we will. But this was raised and actively discussed when the legislation was initially being drafted. But I guess we can look at it again, but we have to decide exactly how small a fish we want to try to get, because we may end up with no fish at all in the net. The suite of legislation, the procurement legislation, the freedom of information legislation, the committee has stated from the last presentation, and Sir David's address dealt with it as well, and our position is that we accept that the supportive legislation has to come, and it has to come quickly. So although it is, small steps, let's just get past this one. But this makes no sense without the supporting legislation to close the gaps and close the loopholes. And I'm assured by the Attorney General that we are coming with all of the relevant supporting legislation in as quick a time as we can. But equally, how that legislation is drafted and what it intends to address will necessarily as well be informed by the provisions, the final provisions of this legislation. So I just want to assure you that it's a work in progress, and that is why we're doing exactly what it is we're doing now. That is why we're soliciting the comments and the concerns of, I will call you stakeholders in this legislation to try to help us to get the most comprehensive piece of legislation we possibly can. I want to say, from the bottom of my heart, thank you for your presentation. You've given us a lot of food for thought, and I trust you will leave yourself open and available to render further advice if the committee should call upon you.
If I may, I was very interested in the ICAB presentation, which I thought was a very good presentation. It made me think. But when it comes to looking at the problem that Jamaica has had with the reporting, it needs to be pointed out that that legislation says that it covers everyone in the public service over the princely sum of 3.5 million Jamaican dollars, which works out in Barbadian terms to 55,000 Barbadian dollars. So it is that broad catchment area that I think has caused quite a lot of the problems that ICAB spoke about persons not putting in their reports that they should do, so that I wouldn't want to extrapolate necessarily from Jamaica on that score to Barbados, because I think in the second schedule, we've gone the other way. I think we are too narrow, much too narrow. We need
Lady
really...
Waldron, would you care to recommend other categories?
No, well, the ones that were
Consideration.
recommended, we've agreed on. There may be others who are in sensitive positions. But as we said, the customs, for instance, comes to mind. So I thought I just wanted to add that. We also have a concern about the fact that administrators of estates, where persons have died, seem to have been given a free, quite a free pass. So we're not sure why. Because an administrator of any estate has a duty to gather in everything, to also know what the debts are, to know what the assets are. And so I would ask that that be reconsidered.
Just for clarity, are you speaking the administrators of the estates of former public officials?
Yes, who have died. Yeah, yeah.
Okay.
Yes. But those are the other matters that I thought we would want to bring up. And there are some members who have asked, why is it that the composition of the commission does not speak to using persons from civil society groups that are established? Well, picking someone from it. We've gone to the church, but we haven't gone to, say, anybody from the social partners or so. There may be a good reason, but we have been asked that, and we are putting that forward for consideration because we are unsure as to why those persons were not included, or someone from those from a social, civil society organization that is well recognized.
Only to offer in respect of your last comment that some agencies of civil society are going to be of long standing. So the Barbados Bar Association, for example. But we had difficulty putting in ICAB, Mr. Brathwaite, because ICAB may be dissolved and a successor organization created. We didn't say, we said the clergy, as opposed to the Evangelical Council. And in fact, we've been taken to task in this very room for using the word clergy and excluding other faith-based organizations. So the difficulty with other civil society agencies is that they may last 5 years, they may even last 10 years. But then once you incorporate it or embody it in the statute, then we'll find ourselves having to do something that was done a few years back. We had to come to Parliament and change the word druggist to pharmacist. So we might have to come to Parliament and change the name of one agency to take account of its success. So I think we try to be as broad as possible. Is it your recommendation, though, that we should broaden the membership of the committee, or just that we should seek to have other representatives on the committee?
The suggestion has been that persons or a person could be used, could be nominated, could be recommended and placed on the commission. But it has to be, when I looked, having heard that suggestion, I went to the Jamaica legislation, and it does have there that among the persons who can be recommended to be on the commission, persons who represent civil society group that appear to be well-established. So I think that well-established part of it, but we thought the Barbados Bar Association was very well established. It may still be, but yes. But you made a comment a while ago which triggered something also in my mind. And it has to do with the fact that there are some parts of this legislation that perhaps we ought not always to have to come back to a full parliament to make changes. When you look at that 1929 Act, for instance, it could have been very useful, even recently. But the problem is, it is that we have this habit here of not bringing fines and things of that order up to date. And there are parts, for instance, of the Jamaican legislation, and I'm a great believer in looking around and see what has worked and what has not worked quite so well, which allows the Attorney General to come to Parliament and make changes in limited areas. But for instance, over a period of time, you may very well find that the particular fine for something makes absolutely no sense. And so instead of having to come all the way back to Parliament, which as a matter of fact in Barbados, we don't do very well, that perhaps that ought to be looked at too.
Thank you very much, Chair. I've been admonished by my colleagues not to overdo the gushing for your presentation. Enough gushing has been gushed, the Chair says. But I do want to take the opportunity, notwithstanding that admonition, to commend the members of the IGB group for what I consider to be an extensively researched and well put together and very well presented submission to the Select Committee. There has been a considerable amount of work done by the group so far, and I want to add to your work by making a request. There are a number of items of legislation which are relevant, which we have been speaking about today, which need to augment the provisions contained within this draft bill. And you've mentioned quite a few of them. And I'd like to ask if it's possible for the IGB to continue its good work by making specific recommendations on some of the provisions that could be incorporated in the specific items of legislation which are going to be necessary to go along with this in order to give full effect to both the prevention, the deterrence and capture and prosecution of persons involved in corrupt acts. Thank you, Chair.
Sorry, inclusion in subsequent legislation or for the purpose of?
No, just send us a written submission, thanks.
Okay.
Lady Warren, there are two things I want to say. One, more important than the next. The membership of the commission, I believe it is a bit restrictive, and that you should not have it so rigid that I'm seeking your, if you agree with me or not, you know? Because let's say you have a person from the legal profession, somebody from the accountants or whatever, but you're dealing with a building project, and none of these people know. You should have people, a lawyer, not necessarily being the chairman, but some person to advise the commission on law, because, you know, the chairman being a lawyer, he's then not going to be advising himself. And that is always dangerous, as far as I believe. You know, so what is your, if you agree with me that it should not be restrictive, but it should be more people from civil society who are of good standing, and then they can hire the services that they need, rather than be having this restrictive lawyer doctor, nurse, surgery man. I know, but you know what I'm saying. You know, rather than have this restrictive, so that you can't branch out. You have people of high integrity, that proven integrity, high integrity, and then they can hire the services that they need rather than have it so restricted.
Yes, well, basically, that is how the Jamaican one is structured. But if what you want is a lawyer to advise the commission, then that's a matter of staffing.
Yeah, because you know, necessarily, because he might not know anything about building, and he might be a building contract or something, you know. That's what I'm talking about. The next thing, you know, it's not substantive, but you mentioned in Jamaica that it is about $75,000 to capture you in the net. So 55 or 55, or that will severely, the senators will be way below that net. So I think that's a good suggestion, Mr. Chair.
That's why there's so many people having to put in these reports, and they're just not doing it. And I'm not sure that it's possible in a country that size, with a civil service that size, to be trying to capture everybody who earns from 55,000 up.
I think it's a good idea. I think that you should have a limit so that, you know, best in time. Like for a person like me, I don't have anything to declare.
Thank you, Chair. I'd like to associate with the sentiments of my colleagues as to the high quality of the presentation of IGB, and to say that this committee, well, certainly the presentation vindicates the exercise in public consultation, and to admit to you and to confess to you that the legislation as it has come to the public is grievously deficient in terms of its exclusion of the companies incorporated under the Companies Act. You would obviously have recognized what we did not recognize. And I have no problem in admitting that no one is perfect. That your recommendation now comes to the committee and would obviously force us or persuade us to amend the second schedule, particularly 5 and 6, where the 3 words established by statute. Yes, I think that's where you were focusing. And that deficiency would have left a number, Chair, of corporations owned by government excluded from the scrutiny of the Commission. So I think we really must express lots of corporations owned by government, except that they're not established by statute. And this legislation presently contemplates only entities established by statute, and those companies that are owned by government, either partially or wholly, as Ms. Archer indicated, would have been left out, and certainly would have been avenues or possible avenues for the commission of infelicitous deeds. So that I think we owe you a debt of gratitude for pointing out that to us. I mean, it's quite perspicacious. We obviously, it went past us. So thanks very much for bringing that to the committee's attention.
Plain English, Mr. Thorne, plain English.
Beg your pardon?
Plain English, Mr. Thorne.
What did he say?
Speak plain English.
Oh, I'm sorry. Thank you very much, Chair. Oh, that word.
Do any other members wish to take the floor? There being none, let me thank you for a long-anticipated presentation, and let me compliment your organization, and I hope that it remains a feature of civil society that becomes well-established. I don't imagine that Lady Warren was plugging for participation on the commission. But let me publicly recognize your outstanding work, which, for which there is no financial reward, but certainly the whole country of Barbados stands to benefit from your eternal vigilance. And we would like to think that whatever legislation we may put in place, that your organization will remain stewards and champions of proper governance in Barbados. I compliment you, and I thank you and all of your officers, present and not present.
IGB wishes to thank you humbly for all of the comments. The gushing comments, yes. Yes, and we are happy to continue helping throughout the process. We will provide the information that Senator Cummins has requested and anything else that you require. Thank you very much for having us.
We will now invite the Democratic Labour Party to make their presentation. The only named representative I have is Mr. Geisa Mears, but I do recognize, I said the only name I've been given, but I do recognize the president of the Democratic Labour Party. Which of you will be making the presentation?
Good afternoon, sir, and all of you. The presentation this evening will be made by our General Secretary, Mr. Geisa Mears. Thank you.
Mr. Mears. Mr. Mears, you have 15 minutes.
Mr. Chairman, let me say at the outset that the presentation you have from us is not what I'm going to follow this afternoon. I would have indicated at the time that that was submitted that it was a snapshot given the 2 days notice that we had to make a presentation. So my presentation this afternoon will look at areas that are wider than what was submitted to you.
Mr. Mears, if I may, if you have another copy, I don't know if you can get it copied while you're presenting, if there's an extra one.
This bill seeks to enter into new territory, not because the efforts to control corruption are new. Our current anti-corruption legislation, the Prevention of Corruption Act, was passed in 1929, and it may still be a useful act were it not for the penalty provisions in it. This bill, however, seeks for the first time to establish an administrative infrastructure to manage the behavior and the assets of specified persons in public life. This component is new. Legislation of this nature cannot really be effectively discussed without accompanying regulations. There's a need for how-to provisions to accompany the broad legislation or the bill that is proposed. It is important in any discussion, therefore, of this Integrity Commission proposed by the bill, for us to have an idea of how the Commission will carry out its work and therefore be able to comment on the likelihood of effectiveness. Further, the bill, if passed into law, without accompanying regulation, will sit on our books without activity for some time, unless the regulations that permit the functionaries to operate are put in place. You note that Section 83 of the bill provides that the Attorney General must make regulations. In light of this, it is recommended that regulations be prepared and form part of the further discussion of the bill.
The actual clause says may make regulations,
Yes.
not must.
May. But effectively, in the absence of regulations, there will be a lack of ability to carry out certain functions of the commission. Section 2, the definition section of the bill, defines prohibited interests as an interest in a contract with the government, the acquisition of which a member of the House of Assembly or the Senate is prohibited on the rules from made pursuant to Section 84.2. But when we go to Section 84.2, we see that the Commission shall make rules outlining the circumstances in which the acquisition by a member of the House of Assembly or the Senate have an interest in the contract with the government is prohibited. In the absence of any idea of what would prohibit a member of the House of Assembly or the Senate from having an interest in the contract, it may make discussion meaningless. And further, I doubt that there are many members of the House of Assembly or the Senate who over time, and I speak subject to correction, I have no data, who over time may have had an interest in government contracts. It is more likely that some of the other persons identified in the second schedule may have an interest in government contracts that is more likely to be the case than members of the Senate or the House of Assembly. We should know, however, that we live in a capitalist country, and there's nothing wrong inherently with a person who comes into Parliament or the Senate having financial interests in other productive enterprises before coming into either house, or even acquiring such interests after. In my view, the main concern is that where there is such an interest, there should be early declaration of that interest and transparency in any selection process. There's nothing inherently wrong with making money honestly. And I'm not sure that being elected to Parliament should cause somebody not to be able to make a decent living once that is honestly done. Section 3 establishes the Integrity Commission, but it does not establish the Integrity Commission as a body corporate to which Section 21 of the Interpretation Act would apply. In my view, were it so established, it would enhance the independence of the Commission so that it would be able to sue and be sued in its own name. It would be able to enter into contracts in its own name, and would be able to regulate its own procedure as of right. Section 3.3 states that it may regulate its own procedure, but that is subject to the provisions of the Act. Were it to be established as a corporate entity to which Section 21 of the Interpretation Act applies, this would not be a hindrance or limitation. If the Commission were so established, we look at Section 11 of the Act, which provides, one, a person summoned to a sitting of the Commission is entitled to have his expenses paid. But subsection 2 states that payment is dependent on whether the Minister of Finance decides that that person's expenses should be paid. And subsection 3 states that the Commission may disallow the expenses altogether. This creates the potential for persons to be punished if their testimony is not pleasing to the Commission or the Minister of Finance. We therefore need to ensure that the Commission is transparent and inherently independent.
Mr. Mayor, just,
You want this come out? You want this come out? Yes, please, sorry.
just to help us, is there a suggestion that you wish to make in respect of that?
He did make the suggestion, and that is that it should be a body corporate, so that it is independent of any political interference. Beg your pardon. The suggestion is that the commission be a body corporate, so that it is independent of any political interference. From the time you interject the Minister of Finance, you are dealing with an entire political organization that follows behind. So, and a cabinet as well, which excludes all other political entities by its very definition.
Okay.
Thank you, Chairman. The commission is an administrative body. It is an investigative body. It is a law enforcement agency with police powers. It is a court with judicial or quasi-judicial authority. Here is an entity that resembles a police force, a prosecutor, a judge, and a jury, and is able to determine matters in its own cause. This is a multi-headed beast that may very well make legal certainty unclear. And one must raise the question whether it offends against the separation of powers doctrine. Section 8.2 of the Act of the bill, proposed bill, provides that the remuneration and terms and conditions of employment of officers of the Commission may be varied, determined and vary from time to time. A previous administration went to Parliament to ensure that the remuneration of public officers cannot be varied downward. Is it proposed that the persons employed by the Commission will not benefit from the protection that constitutional amendment provided? There's nothing in here that indicates that these officers' remuneration may not be varied downward. Section 10.3 of the Act excludes the application of the rules of evidence. The rules of evidence were created to ensure fairness and the delivery of justice. Yes, the rules of evidence are sometimes relaxed in instances, for example, of a commission of inquiry, where one is focused entirely on the gathering of facts. But an entity of this nature, with the potential to criminally convict persons, the rules of evidence become important and indispensable to the process that persons coming before the Commission may have to undergo. We invite you to reconsider the relaxation of that requirement in the proposed bill. The bill, as it is currently structured, encourages opinion evidence with letting hearsay evidence. And when you look at the importance of the reputations of persons who are held up to scrutiny, it is important that there is no unfairness in the process. Section 28 provides for a specified person in public life to place assets in a blind trust. I haven't seen this concept of a blind trust anywhere in our laws prior to this bill. The first glimpse of this is in subsection 5 of that section. And it says that a blind trust is created when the specified person in public life enters into an agreement with a qualified trust company for the storage or management of his assets. Interestingly, this qualified trust company may be partly owned by the person whose assets are being placed into the trust. However, I do not think that the blind trust advances the prevention of corruption any. It does not address how the assets were acquired. So you can steal, you can take bribes, you can do whatever. And once you have accumulated the assets, then this provision allows you to place those assets into a blind trust, which may not be very blind after all. Rather than helping to prevent corruption, it might very well conjure up the image of something that is structured to protect corruptly obtained assets. Sections 29 and 30 seem to bring the Governor General into the arena where the Governor General now has to conduct inquiries behind information already received. Of course, there is no mention of any additional resources given to the Governor General that will conduct these inquiries. It is unusual for the Queen's representative to be given executive powers to sully her hands with inquiring into matters of this nature. I think we may do well to reconsider the import of those two sections. Section 64 is interesting. It provides that a person may lodge a complaint with the Commission on hearing an allegation in public of a possible contravention of the Act. There is no locus standi requirement. There is no threshold of knowledge or information. It seems to suggest that it is sufficient for a busybody who listens to a call-in program and hears something to go ahead and lodge a complaint with the Commission. This opens the Commission, I think, to abuse and will waste the Commission's time to a large extent. The penalties contained in the bill are not dissuasive. The maximum penalty anywhere in this bill is $20,000. Compare this with penalty provisions and other relevant existing legislation. Section 79 of this bill seeks to ensure that information gathered is treated confidentially. A very noble, a very good thing to do. It carries a penalty, though, of a breach of a fine of $5,000 or 2 months imprisonment. A similar offense in the Money Laundering and Financing of Terrorism Prevention and Control Act carries a penalty of $100,000 or 5 years imprisonment. A person convicted of money laundering on indictment is subject to a fine of $2 million or imprisonment for 25 years or both. I think this comparison starkly underlines the inadequacy of the penalty provision in this bill. And the amount of the punishment that is attracted will not dissuade persons who are minded to engage in serious corruption. As a general observation, we must understand how entities established by the bill will function, and this requires regulation. We must find a better way than bringing the Governor General into the arena of inquiries. And we may need to understand how the penalties in this bill are justifiably as low as they are. Mr. Chairman, I have submitted earlier comments, which, as I indicated, I did not allude to in this presentation. But if the committee is so minded, we are willing to merge those comments with this document and resubmit the entire presentation to the commission as one document.
Any dissent? There being none?
Thank you.
Is that the end of your presentation?
Yes, it is.
Just wanted to clarify two things. The involvement of the Governor General in receiving declarations only relates to the members and the staff of the commission itself. You would appreciate that they cannot file declarations in respect of their own assets with themselves, and the only higher body for this purpose would be the Governor General. And there are a number of things that the Governor General does do administratively, and you can rest assured that the Governor General will be given such resources as are necessary for her to carry out this function. The other matter, and we've now heard it several times, in relation to the level of the fines, the level of the fines will not stay as are settled in the bill. We welcome your contribution in that regard, but on the very first day that this matter was debated, it was indicated to Parliament that the level of fines will go up significantly. And certainly as Attorney General and being responsible for the drafting of it, we will be looking to pitch them in the same region as the anti-money laundering legislation. Any questions for the representatives of the Democratic Labour Party?
Mr. Chair, before we move off that point though, in section 29, the Governor General also is given the authority, a matter of fact, it says shall make inquiries. So it is not as simple as receiving the declarations, but there is an investigative function that is given to the Governor General, which in our estimation goes beyond her remit as our head of state. That is the concern that we have.
What is the Governor General's remit?
She's the Queen's representative in Barbados, and the Queen traditionally does not descend into the arena. And that is the concern that we have, whether or not she would be doing a little bit more than the Queen actually does herself, being the Queen's representative.
Noted.
Thank you.
Just to allay your concerns with respect to the Blaine Trust. The Blaine Trust don't, if you read the section carefully, the Blaine Trust don't allow people to take bribes, then deposit in a Blaine Trust, and continue to take bribes and then deposit in a Blaine Trust, right? At any time that you deposit your money into, or place your money into a Blaine Trust with a reputable trust company, you have to declare the value of the trust at the time that the trust is created. So it doesn't allow you to shield your income. I mean, if I put $10 million in a Blaine Trust, I have to declare that I put 10 million in a Blaine Trust. And I will still have to answer as to where that 10 million came from. What the Blaine Trust does is isolate the money. Isolate the money.
Well, there's a further consideration, and in the 2012 Act, there was a definition in Section 2, which dealt with associates, which has been seriously decimated in the 2018 bill. The 2018 bill speaks only to family members, whereas the 2012 Act spoke to partnerships, associates, even close. You can have a close family member who is not as close as your spouse and your child, but your brother could be extremely close to you, and you could set up sufficient to bypass the provisions of this bill if you don't have those categories that wide.
Okay, then, as you were planning to augment what we have in front of us, then I would suggest that you include all such suggestions, and the committee will consider them and draft accordingly. Thank you.
Thank you. Thank you, Mr. Chairman. Mr. Mears or Mr. Pisa, I'd like to hear you on the two things, really. What is your party's position on the confidentiality nature of this bill as it relates to the persons who will be called upon to make the declarations? And secondly, what is your view on the constitution of the commission itself?
In relation, if I may take it in the other order, in relation to the constitution of the commission, the primary concern is that everybody seems to have the same function. That is to say, the investigative powers are globally mentioned. The trial is also globally mentioned. We have a judge, and I assume that the judge will be the person who will be presiding over the hearing, but is the judge also intimately involved in the investigative side of things? So in terms of the composition of the commission, what we would prefer is that there be some disparate division, some division of the labor, so that even though it is one commission, they're not all wearing different hats at the same time. It helps with the separation of powers, it helps with transparency, it helps with not being seen to be easy to influence in the process. If one person or one commissioner is wearing all these different hats, then there is the greater likelihood of justice not being seen to be done, even if it is being done. So it is not so much in terms of who sits on the commission, but what functions do they carry out once they are there. And in relation to confidentiality, the committee has said that they're going to revisit fines, and this would be one area where you would need to have prohibitive provisions in terms of the disclosure of what is essentially private information. It is delving into the private lives of public people in a fairly intimate way. It doesn't only stop at them, it extends to spouse and children, and the confidentiality provisions in terms of keeping the confidentiality need to be just as strong in terms of penalty as those persons who are committing other infractions, because it could impact on their personal lives if certain information gets out, especially if it is in an investigation that the information leaks.
I think
I hope that,
sorry.
go ahead.
I think too that this is where the importance of regulations come into vogue, so that the commission may set out specifics that may not find their way into the bill as currently drafted, that will govern the control, storage, and treatment of information received by the commission. That information is not currently in the bill. I do not expect it to be, because I think it is better dealt with by regulations.
I think what also is a glaring omission for us is that the code of conduct has been hived off now out of, it was present in the 2012 Act, and it now gets a mere mention in the 2018 bill. And that code of conduct, I think, needs to have the strength of primary legislation and needs to be brought back into the body of the Act, mentioned in the body, specified in the schedules, so that not that secondary legislation has any lesser power, but I think it is better placed within the body of the legislation itself, as opposed to merely mentioned and then moving on. Because it also will speak to how confidentiality is treated in relation to how commissioners and their staff will operate.
Followed by Senator Tate, then Leader of the Opposition, then followed by Minister Jordan.
The 2012 bill you're speaking of, or act, is the one that was never proclaimed?
That was never proclaimed.
Isn't that a thing?
Yes, it is.
Yeah. With respect to the commission, the constitution of the commission, can I hear you on your views on whether persons, I believe that the Prime Minister is entitled to appoint someone, somebody correct me, because I can't find.
And the leader of the opposition
The-
as well.
Yes, so the Prime Minister has somebody on the commission, as does the leader of the opposition, is that correct? Am I right? I remember we had Dr. Aline here earlier, and he spoke to being cautious and to ensure that we have a commission that does not speak to political affiliation. Can I hear you on your views on whether you believe that a prime minister and a leader of an opposition, who are both political creatures, should have a seat on the commission?
I think it makes more sense for
Wait,
political.
I don't mean to cross you. Bearing in mind that it is those persons in public life that are going to be the subject of this legislation. I perhaps should have ended off by saying that. So in the context of the legislation, not in any way casting aspersions on anyone in those various roles, Bishop, I just want to say specifically, I just want to hear from you as a political party, what is your position with a commission who is supposed to be removed from political affiliation, hopefully, and who will be able to hopefully ensure confidentiality, even though I heard ICAB talking about interactive electronic submissions, so I can't wait to hear what that means without being hacked. But I would like to hear you on whether there should be anyone sitting or appointed to a commission that is dealing with integrity in public life that should be a representative of a political creature. And that not only means actually having someone sitting on the commission, but advising anybody or consulting with anybody as it relates to the goings-ons of the commission. Thank you very much.
You widened it significantly in
Yes, I
that
did.
last statement. So I will deal first with the narrower issue of representatives of political parties being on the commission. I think in the context of a bill, an act, which places responsibilities on political parties, that is to say that there's an element of reporting, which was in the 2012 Act, but is not in this one, this bill. If it is a situation where there are obligations, then I have no difficulty with political appointees on the Integrity Commission. It would bring some balance. What we would need to caution, and I'm thinking now in terms of the configuration of Senate, if the membership of the commission is heavily weighted in the favor of any political entity, then there could well be a taint in any of the deliberations that they have. I think that is a given, and I believe that is why the legislation as drafted gives a greater number to the Governor General in terms of appointments. However, I think we have had in Barbados that practice. The appointment of judges comes immediately to mind, where there is involvement of senior politicians, and I suspect that is the reason why that path was followed. To go on then to your wider issue, in terms of the possibility of taint, where a political operative wears another hat as a lawyer, as an accountant, can they be giving guidance? I think Gyson's point in terms of being able still to make a living has to be taken on board. But I believe that the commission in both iterations, the commission was given sufficient power to sanction if there is any way that the commission comes to the view that someone is misusing the commission. So I think it balances itself out. They're present on the commission, but if it is that you mash that crease, that there will be sanctions to flow.
Thank you very much. Thank you, Mr. Chairman.
Yes, go ahead.
Thank you both, and good afternoon. Just want to hear you further on your comments. Section 57(3) sets out what penalties shall be imposed by a court in the case of unaccounted for property or resources. Your position is that this seems to be a usurpation of the role of the judiciary and may in fact be unconstitutional. Just like to hear you further on that, and perhaps, Mr. Chair, if I can hear one of the legal voices on the commission.
This is simply a reflection on the view that the legislature cannot usurp the position of the judiciary in terms of imposing a sentence on anybody. So that if you legislate what a penalty should be, it's the legislature imposing the penalty and not the judiciary. And this comes into vogue largely with there are mandatory sentences that are imposed. It's the same principle that the legislature should be slow to tell the courts or any judicial entity what sentence should be imposed. And that is where that comment is grounded. The other issue?
Only to point out that the Interpretation Act, Mr. Mayers, does say that where a term of imprisonment is stipulated in the statute, or where a fine is stipulated in the statute,
Indeed.
it is to be interpreted as to encompass all terms of imprisonment or all fines that are lower than the stipulation. So if you say a person shall be liable to $500,000, the Parliament, not the Parliament, the court has the ability not to impose the 500,000, but to impose 300 or 3. And that is what the Interpretation Act says in relation to stipulations as to fines and to terms of imprisonment. So unless you're suggesting that this statute is not to be governed by the terms of the Interpretation Act, I would like to suggest that that particular expression of law is not accurate.
Not being suggested, but permit me when we resubmit to address that to you, sir.
Chair? Thank you. Oh, sorry, go ahead. I didn't realize.
Thank you, Mr. Chair, even though you forgot me. I thank Mr. Mears and Mr. Pisa. For clarification, I was listening to your presentation, but I looked at the last line of the submission and the second submission, sorry, and wondered if you were supporting legislation to govern integrity of public life, or if you were suggesting that maybe there were already instruments or constructs in place that could manage members of Parliament, and I'm assuming that by that you probably might be including senior civil servants, senior public servants as well. Are you supporting the need for legislation to be in place, or do you think that there is already something existing? Because your statement says, but it asks the question, have you lost faith in the existing organs of the state so that we have to create an entity without parallel to manage members of Parliament? I'm just asking for some clarity on that. What is your position as a party?
A deliberately provocative question. But it does not indicate that we are not supportive of a need for integrity legislation. In fact, the previous legislation is 2012 was, I think, effective in trying to answer this question for me. And I because it took into account things that I am particularly aware of, that the international conventions demand of us that seem to not be taken into account in this piece of legislation. But this does not say that we should not have integrity legislation. It begs the question, however, whether we have already effective assets that would address the major issues that arise with respect to corruption.
I will say, though, that I found it curious that the bill does not in any way make reference to those international obligations that we have, the conventions, not even a passing reference. And I wondered if it was because certain sections have been hived off, which would be required by that legislation, and that have not come as yet. And in relation to the involvement of public bodies, I beg your pardon, in relation to political parties and in relation to private bodies that get involved in public activities, and which the procurement legislation would address. But we've been told that these other pieces of legislation are coming, but without the specific reference to the conventions, the Inter-American Conventions and the UN Conventions, it makes you wonder whether this legislation was even intended to meet those international obligations.
I would only say in response that Barbados is a party to numerous conventions, and we've passed numerous pieces of legislation that are compliant. There's no obligation to mention any particular convention. Certainly the Constitution of Barbados, which guarantees human rights, then does not make any mention to any of the previous conventions which Barbados would have been a party to by virtue of being a colony prior to 1966. I will also say to you that there's sufficient jurisprudence coming out of the CCJ now that tells us that our international conventions are binding. And for Mr. Brathwaite, I'm able to confirm that Barbados did sign the Inter-American Convention Against Corruption on the 5th of January this year. If there,
Can I just
I'm
ask
conscious
one more
of
question?
time.
Yes, just one more question.
And we have 2 other presentations to go.
May I proceed?
Yes.
Ms. DePisa, is it that, based on your comments, you're saying that an absence of these various references causes the bill to be flawed or deficient? Is that what you're saying? Okay. Thank you. Well, good. Just seeking clarity.
I'm afraid we have to conclude the presentation now from Democratic Labour Party. Let me thank you for that. We will now have yes, the Barbados Kingdom Alliance, and then Ms. Eastman from the United Progressive Party.
Marshall,
We are happy to keep working.
did you thank the people and invite them to stay?
I thank you very much, Mr. Mayers and Mr. Pisa. Please consider remaining with us if you wish.
Making things obvious?
Apostle and Mrs. Scantlebury, is that the appropriate nomenclature? Let me welcome you both. You have 15 minutes. You have this presentation, right? We have their presentation.
Good evening to everyone, and my name is Apostle Linroy Scantlebury. This is my wife, Prophetess Heather. And first of all, I want to say a very special thank you to the members of the Select Joint Committee for the invitation and the opportunity to be here with you this evening to share our submissions on the Integrity and Public Life Bill. I also want to add that I would like to applaud the efforts of this present administration to expedite this process. I think this is something that is long in coming. and it is also, in my opinion, very necessary for Barbados in terms of moving forward as a nation. I took the opportunity to carefully assess the Integrity and Public Life Bill, and as a ministerial leader, my focus was more on the formulation and the proper functioning of the commission, and not so much on the element of corruption, because we're very well aware that Barbados, as a nation, has experienced tremendous levels of corruption, not just in terms of our political arena, but in many areas of life here. I looked very carefully at the area of the commission regarding integrity and public life, national building, the protection of our country's good name, and then also the element of the integrity of the commission itself. And these areas I consider to be very important as we pay attention to alleviating the levels of concern regarding corruption in the island of Barbados. Now, I want to make this abundantly clear that as it relates to our public servants, we have here in Barbados a national pledge that makes it clear. It is a verbal contract by any individual assuming the role of government and those who operate in our public service, that they must maintain the highest levels of excellence and integrity as individuals. And let me remind you, the pledge says that I pledge allegiance to my country, Barbados, and to its flag, to uphold and defend their honor, and by my living to do credit to my nation wherever I go. And I think it's very important for our public officials to understand that they have a greater role than regular citizens to maintain these high levels of excellence, these high levels of integrity as we operate. Okay, I'll settle down. High levels of integrity and excellence as we operate in our office. So I think it's very important that as we look at this, that we continue the importance of instilling in our public servants the ability and the importance of keeping agreements and keeping oaths and making sure that they do what is necessary to continue our trend forward as a nation and become discerning and watchful for traps, especially with the new president getting rich through position schemes, misuse of power, and return to the ideals of serving our people and serving our nation with integrity and with excellence. Now, in my opinion, in addressing this integrity and public life bill, and we just had roughly about 2 days to actually get our submission in, and so what we presented does not fully express those things that we really wanted to say at this time, but we are willing to present to you an updated version of what we have already presented. And if you pay attention closely to it, you will realize that we focus more on the commission itself, on the structure of the commission, on the purpose and vision of the commission, and how the commission actually carries out its responsibilities. And I consider this to be very important because corruption itself is on another tangent, and I believe that this commission is being designed to deal with elements of corruption that may incur after the formulation of the commission. We've paid very close attention, especially to our structure, and we gave our structure for the commission and how we lay that out, and that's exactly how, in my opinion, I would love to see how this commission organized and structured. Secondly, in terms of the individuals within the commission and the them taking the oath of office, I think it is going to be very important that we pay close attention to the types and quality of individuals that will be a part of this commission, because it does not make sense having this bill on integrity and then those who are operating within the commission are not themselves individuals of integrity. I think this is very, very important going forward. Barbados is at the point right now where it is basically reeling from a number of things that are happening here within our nation and also overseas that's greatly affected who we are and where we are in terms of our politics and in terms of where we stand on the global scale. And I think the time has come right now for us to be very careful and very concerned that we do what is necessary to make sure that we put this country back where it is supposed to be. I actually want to make a suggestion or a couple of suggestions, and again, adding to what we submitted. And I want to go ahead and make these 5 suggestions before I say anything further. I know that we are pressed for time, so I want to be as quick and concise as possible. My first suggestion is, number 1, for a member of the commission to be present in government decisions where large contracts are being rewarded or discussed. Secondly, for the Electoral and Boundaries Commission to come under the commission in relation to funds to political parties and distributions of said amounts. My third suggestion will be to address the conduct and also the misconduct of members of parliament. Number 4, to bring companies owned by government under the commission. And then my 5th suggestion would be to revise the penalties as it regards those individuals who are brought before the commission and subsequently sentenced. Now, these are my 5 areas that I want to look at. I will be resubmitting these in an updated draft of our submission. And with all of this in mind, I want to add to the fact that as it relates to individuals, learning a person's assets and business associations does not really expose the mindset or the heart of the individual. And we have to understand that. Whatever we do, people are going to find ways and means to find loopholes and cracks so that they can continue to do what they need to do. This commission, in my opinion, must stand as a guard against, a deterrent rather, against any individual who will try in their manner to continue the work of corruption, and also those who will try to influence those who serve us to become a part of their organization or their activity. I think it is vital to understand also that a bill which in some way encourages our citizens to become private investigators themselves and to offer them some type of incentive, monetary benefits and protection for information on the corruption of others, in itself is an act of corruption. And what we must understand, again, as I said, in regards to our pledge, is that we must begin to instill in our people, especially those who serve us, that it is important.
If I may, can you just repeat that point again, please? The last point.
In regards to the whistleblowers?
Yeah.
With, okay, let me pull that up. A bill, as I said, which encourages in some way our citizens to become themselves private investigators and giving them the incentive of the offer of monetary benefits and protection for information on the corruption of others is in itself an act of corruption. Okay? And I want to make this abundantly clear that I am in support of any attempt to limit the level of corruption that is here in Barbados. And I said in the beginning that I support this administration for expediting this matter. I think it is long in coming. I don't want to make it abundantly clear to everyone that's here. We have a responsibility to maintain Barbados's good name, not just for ourselves, but we need to do it for our children and our grandchildren. And what we have right now is something that a lot of individuals, if they're honest, we're not happy with. We need to do something with the levels of corruption. We need to do something with people breaking the law, getting away with it. We need to do something with making Barbados wholesome again. And I think it's incumbent on all of us who are here to be very circumspect as we put forward this bill to make sure that the proper functioning of the bill and the manner in which we enact this bill is actually going to work. It's actually going to do the job that it is designed to do. And if we do it, I believe that we can have a better, brighter, more successful, and more prosperous Barbados. Okay. Okay, my wife has asked me to define companies owned by government. Now, I want to make mention of areas like our seaport, especially the Customs and Excise Department. And honestly, I would love to have, if it works out this way, I would actually love to have the presence of someone from the commission at certain ports of entry, especially or seaport or airport, and possibly elements like Port Ferdinand and Port St. Charles, and even possibly the Ararat Cement Plant, because these are other ports of entry that, in my opinion, are responsible for much of the corruption that is going on in Barbados, and I want to make sure that if I'm quoted fairly and openly. But this commission must be very serious in understanding that you cannot play games with individuals, no matter what their economic standing is or no matter what their position in Barbados is. If you defame or you break our national pledge, you should be judged accordingly. And I think, again, with the element of our penalties, which I consider are very weak, these amounts can be easily paid off by individuals who operate with large sums of cash. And I think we need to put penalties that when they are mentioned, the penalty itself is a deterrent. And so these are just some of the things that we want to add to our presentation here on today. And we are willing to do our part to aid the commission to make sure that in Barbados, the levels of corruption are greatly reduced and the level of governance in Barbados regains its position and regains its operational procedure to make Barbados what it is destined to become. Thank you very much.
Some questions? Well, you want to? Okay, I'll defer to Senator Cummins, and then I have a few questions for you, sir.
Thank you very much, Chairman, and I wish to thank Apostle Scantlebury and your wife, Prophetess Scantlebury, for taking the time to join us here today and making
Thank you very much, ma'am.
presentation. I just wanted to, it would be remiss of me, and I know that there are about 300 workers in the Barbados port who would be very unhappy with me if I did not seek to clarify that there are subsidiary agencies that function within the port, but they are not part of the port. And so when you mention some of the agencies that you are minded to have brought within the ambit of the legislation, let it just be with a clear understanding that those are not necessarily Barbados port agencies. There are separate agencies that function within the confines of the port. Thank you.
I do recall that there was also some time back the decision to place cameras within those agencies that created a firestorm here in Barbados. So I understand where you're coming from. Thank you.
Apostle, if I may, it is interesting your perspective on the whistleblowers and incentive A for the whistleblowers and B protection for. Almost everyone who has presented has actually asked for the whistleblower protection and actually separate whistleblower legislation. That is a common feature coming out through the presentations and from input from Weather Barbados. The incentivizing whistleblowers is seen increasingly so internationally as the only way to get the information, the lesser of the evils. So I would actually just like to hear your perspective on why you think that is in itself a form of corruption, because it is a novel perspective. So if you can develop that one, please.
Well, we have to understand that information coming from individuals, information coming from individuals within the wider public is subject to scrutiny. And we're looking at the fact that a lot of the information might not necessarily be accurate. And how do you, during the process, how do you determine information from a whistleblower that's accurate information versus malicious information? Okay? I think, again, the commission, in terms of its function, its operation, should have levels where even within the financial institutions, within large companies in Barbados, that individuals who would see some levels of infraction should be able to communicate openly or privately with the commission. Okay, I don't really subscribe to the idea of any individual or every individual. You're hearing a piece of information, you haven't done the necessary work to determine whether that information is accurate or correct, and you call the commission or you inform the commission. I really don't consider that to be a proper way of functioning.
The draft itself provides for malicious complaints or frivolous complaints. The reality is the work of the commission or any investigatory body can only proceed on the basis of evidence. So somebody at some point in time has to say this person did wrong.
Okay.
So I can maybe even see, because the jury is out and there are two sides of whether whistleblowers should actually be paid for their information or be incentivized to expose infelicities. But I would like to hear your position in relation to the protection for whistleblowers, because one of the big issues that we face as a country and getting people to come forward is the fear of victimization. So if we don't have legislative protections for the people who have the evidence on which we can proceed, then how would you suggest that we actually get people to cooperate?
Okay, well, here's my point about this. Again, all the information that the commission will receive from whistleblowers will not be accurate. Do we protect individuals whose information is not accurate? At what point do we protect those individuals? From the moment we get information from them, does the protection begin? At what level do we protect those individuals at, based on the information that they're bringing to us and based on the individual or individuals that they're implicating? Okay, because I think that at this point it's going to be necessary to have a level of where we decide this person will need protection. Okay, I really don't see the need that the moment someone says, okay, well, I have information on XYZ individual, I think it's the commission's responsibility to receive that information, begin some level of investigation on their own, and then determine at what point this person needs protection.
May I add something, please? I think that one of the things we have to consider is that we don't want to put that level of responsibility on our citizens. We are in Barbados and things are rumored and you hear things. I think it's the commission's responsibility that when things are rumored, they then provide the person that can investigate without people knowing, like an operative, and then they can report back to them with the kind of information, because the commission will have trained people. You hear rumors, and then you can plant somebody there that can bring the relevant information you need rather than waste time and you go forward. I think that that should be, instead of having whistleblowers, I think that when we hear rumors, it's the commission's responsibility to determine whether we're going to plant somebody there to see if what is going on is actually true.
Okay, what I will say is that this has shown us that we perhaps need to explain the whole whistleblower concept a bit more. I can assure you that no one will be prosecuted and convicted based simply on the statement or reckless allegation of somebody else. Any information that comes to the commission, whether it comes by way of a whistleblower, whether it comes by way of the commission's some other informer or some other method, will be fully investigated before anybody is disadvantaged under this legislation or convicted under the legislation. Evidence will be presented and the person will have a chance to answer. So it will not be simply a case of the commission taking the malicious say-so of anybody. So all evidence, all reports, everything will be evaluated, it will be investigated, and then the process will start. So I wish to assure you that this will not be a case of someone that your neighbor does not like you, and they make a complaint or provide information against you, and on the basis of that alone, you are convicted. This will be full, fair, in accordance with natural justice, so that people will have a chance to defend themselves and present their own side, and the findings will be based on fact. The Integrity Commission is expected to operate in the same way at the investigative and at the tribunal level as a court, and to the same high standards. So rest assured that full investigations will be done before anyone is disadvantaged on this legislation.
Well, that's one of the reasons, I may say, that we determine at what levels whistleblowers receive protection.
Just one quick word before we must end your presentation. You say that you felt the commission should be notified of the entry of new companies coming into Barbados?
Yes, sir.
And background, affiliations, and so on. While that is laudable, we have, well, I'm not going to say I've narrowly met, but you know, you may not have a new company, but the shareholder of an individual may incorporate a new company. Hundreds of companies are incorporated in Barbados every week, some with foreign shareholders, some with local shareholders. Now, this would require a level of due diligence, which I wonder if you don't consider to be too costly a burden to bear. ICAB spoke earlier about risk-based analysis and risk-based investigations. If a company is not, suppose a company comes into Barbados to sell snow cones, their likely interaction with government is going to be limited. The volume of business that they're likely to do is going to be quite small. So perhaps you would want to consider limiting the scope of this inquiry.
Well, possibly, but I added this with the idea in mind that some of these companies that are coming into Barbados with individuals who are either owners or shareholders may have been implicated in some level of corruption, maybe in another country. And I think that we need to take this into awareness when we're going to allow companies to come into Barbados with questionable characters, either as at the helm or as shareholders.
You had indicated that you wish to supplement what you sent in.
Yes, sir.
So I look forward to the committee receiving that as soon as possible, that we can factor your considerations into our deliberations.
Thank you very much, sir.
Thank you very much for your participation. I now invite UPP.
Thank you.
By its president, Lynette Eastman, to make her presentation. Apostle and prophetess, please feel free to stay with us.
Good afternoon. You're using your mic. As soon as you finish.
Good afternoon, Mr. Chairman and the members of the Joint Select Committee. I would like to take the opportunity to all of those individuals who I have not been able to see individually. I would like to congratulate globally for your various appointments and elevations in recent times. This initiative to put in place very quickly the integrity legislation and to get comments from the public, I think is a very good one. It's a very good start. I will try not to repeat what others have gone into in great detail, except maybe to support what some of the other interventions. But I would like to start by saying that I believe that those in leadership positions in Barbados really need to take on board the devastating effect which corruption has on a country. And, you know, a long time ago when Michael Porter wrote his book on competitiveness, he said that really countries choose poverty when they allow their practices to be corrupt, either that they become corrupt through inefficiency or the corruption itself creates a quagmire, which makes it even more inefficient. And then you have even more inefficiency and more corruption. And it is very important for us and for those in leadership positions to make it very clear and to be themselves clear that it is not just a moral issue, it is an economic and social issue. The countries that you look at on the Human Development Index, which tend to always rank in the top 10, are also those countries which pursue anti-corruption measures aggressively. So whenever we talk about countries like Singapore, and we talk about the Nordic countries, and we talk about New Zealand, we talk about their economic growth and development. And we think it may just be an economic issue, putting good economic policies in place. It is also because they've put strong measures in place to fight corruption. So it is really to the benefit of all of Barbados and all Barbadians to ensure that we do our best before it becomes worse to deal with corruption, the corruption which we now have in Barbados. I think that what we need to do is to really examine the type of corruption we have in Barbados and seek to address it through legislation. So this is why there are certain issues that will arise that are peculiar to us. So it isn't simply following a model piece of legislation from somewhere else, even though that is helpful. But we have to look to determine where the corrupt practices are most severe and to seek to address them. Now, as I said, I'll try not to repeat what has been said before, but I would like to support those who have stated, those interventions that have supported the fact that we should have had a code of conduct to examine at this point in time. We also should have been able to see what exactly is meant by a prohibited interest in a contract. where a member of the House of Assembly has such an interest, it's important that we know exactly the scope of that. Currently, we do not. It would also be a good thing for us in Barbados to get into the habit of presenting our regulations, our draft regulations, along with our bills. Quite often we don't do that, and certainly with this type of legislation, we think it would be important if the regulations had been presented as well. Sometimes there's a lot more substance in regulations than there might even be in the skeletal bill. So what I will do is identify the areas that we thought were important. One of the most important things, of course, is having integrity within the commission, and that it should not only be actual, but it should appear that way. And it is for that reason that we're recommending that neither the Prime Minister nor the Leader of the Opposition should play a role in determining who sits on the commission. Now, I know that within legislation across Barbados, it is the practice that the Governor General will consult with the Leader of the Opposition and the Prime Minister in many instances. We think it is inappropriate, especially in this piece of legislation. It will appear to the public as though we are really not serious when we are going to take the leaders of, the two major entities that could be involved in corrupt practices. I have no difficulty with the Governor General, as some people have said, descending into the arena. I think the Governor General is there. I don't see any reason, if we have to call upon the Governor General to consult with other persons in choosing those commissioners. And I believe that there should be enough people of integrity in Barbados that the Governor General can consult with those persons. As I said, I know it is the tradition, but if I look, for example, at the Electoral and Boundaries Commission, where it is also the tradition that there should be a representative from the opposition, representatives from the government. What happens is that decisions made by Electoral and Boundaries Commission will be in the interest of politicians. And the interests of politicians do not always necessarily coincide with the interests of the people. That's just a fact. Politicians are a class of people together. And sometimes what is in their interests really is not in the interest of the people.
Sure, you meant our.
What? Our what?
You said their. I said, sure, you meant our.
Oh, okay. Thank you. So that is our view, and we understand that it is not the tradition. So it may be a difficult thing to argue, but we really think that Barbados really needs to get serious about disciplining itself. And therefore, that is our recommendation. Because of the various interests that individuals have in so many different projects across Barbados, our recommendation is that as far as possible, these individuals should be retirees as far as possible, so that they don't have that interest in much of what is going on in terms of awarding contracts, etc. But the most important thing for us is to ensure that the individuals, apart from everything else that was discussed, whether they're specialists, whether they're from NGOs or whatever else, the most important thing is that these people must be people of integrity. And I do believe we have a big enough pool in Barbados that we can find those people of integrity. In terms of the commissioners themselves, we do believe that there should be protections for the commissioners. and that where individuals are found to be engaged in any activity that would make it difficult for the commissioners to carry out their functions, that there should be severe penalties for that. Now, it did cause me some concern, though, that there's a provision where there's quite a stiff penalty if you insult a commissioner. And I don't know, a commissioner could be easily insulted. I don't believe that such a provision should be in there, and that I don't believe that the penalty should be that high. I think it's like $10,000 or something like that for insulting a commissioner, and it's just kind of odd that it's in there. When, generally speaking, you would expect individuals to conduct themselves in a particular way when they're in a particular forum. I am more concerned with attacks on the commissioner, threats to the commissioner, but not insults. I mean, an insult could be that I think your head is very big. And I would find it very difficult to imagine that somebody would be penalized for that. Now, we go on to capturing the individuals in the net. Now, we had a bit of a discussion about companies that are incorporated by entities which are government-owned. And we also have entities in Barbados that might not be incorporated by government, but in which the government has substantial interest in terms of shares. They have equity in the entities, even though they're not incorporated under any particular ministry or particular piece of legislation or statutory corporation. So there are those entities that I think that we should also take into consideration when we're looking at making sure that the net is wide enough. There's also I know that we've tried to define you've tried to define in the legislation how far we should go in terms of looking at individuals who are connected to the specified person. So you look at spouse, you look at children, you look at individuals living in circumstances of husband and wife. And we know that there are individuals who live in circumstances which sometimes might even be closer than husband and wife. And it seems as though those individuals might not be captured in the legislation. And it is certainly important that we capture all of those individuals as well, I would think. Now, I know it might be a bit difficult, it might be difficult to define them, but I would suggest that instead of using the term circumstances of husband and wife, perhaps you could use a term that really defines that closeness between the individuals. Because, it would be a sad thing if a person just got away with it because they're neither a spouse, child, nor living in circumstances of husband and wife. So we think it is important that we address that particular issue. And I would also like then to support the point concerning the fact we're focusing heads of department, but I would also like to support the interventions which suggested that there's a need to look at those people who are most susceptible to corruption. Quite often it is not the head of department, but there are individuals who interact with the public who are most susceptible to bribery and corruption. And this is why I said initially we have to look at the profile of corruption in Barbados and try to address it. I know that we don't want to go too broad and make the net so broad that we encompass everybody in Barbados, but I think it is internationally recognized that there are certain agencies within governments around the world, it's not just us, where the officials are more open to corruption and bribery precisely because of the positions that they're in. And we think that it is important that we address those individuals. We also support the point that after a person has died, this is in clause 25.7, because a person has died, we do not believe that there's any reason that the administrator should not file a declaration. We might actually be in a situation where if an investigation is being conducted, and quite often where people are engaging in corrupt practices, they're quite often not engaging in them alone. They're engaging in them with other parties. So simply because one person dies, it should not mean that you would not have access to that information to pursue the other party. So it is our recommendation that death should not prevent the administrator from doing what the person, if he or she were alive, would do. Now, there might be certain safeguards you have to put in place for the administrator. You might wish to give the administrator more time. You might need to assist in some way because the administrator is not the person. But I think that those are things that we could address. But certainly our recommendation is that that requirement, well, that privilege should not be there in clause 25.7.
Ms. Eastman, just with an eye on the clock, we note your excellent presentation, to be honest, and I like the format where you set out your concerns and you also specify your recommendations. That is very useful. If you can take us to the specific points that are most burning for you.
Okay. Well, how much more time do you want to give me?
I guess 15 minutes starting now.
Oh, okay, there's a lot of time. Okay, so ensuring that the Governor General can carry out her functions, I think that's very important because within the legislation, you do put emphasis on seeking to ensure that the Commission has resources, but there isn't very much about the Governor General now having additional resources in order to carry out her functions. And as we are suggesting, the Governor General should take on that responsibility of appointment and filling vacancies, etc., in consultation with some other person, but not the Leader of the Opposition and not the Prime Minister. So the Governor General needs to have those resources, and we're making the point that they should do so. Ensuring that the Commission has teeth. Well, the commission itself is given the power to send reports to the DPP, to have certain matters pursued through the courts. But we are a bit concerned that in doing so, the commission does not give up its interest in the matter, that it should not just send the report to the DPP or send a report to the Commissioner of Police and basically leave it in their hands. There must be some mechanism for the commission to retain an interest in the particular matter. Otherwise, we might find ourselves in a position where whatever they pass on just gets caught up in the backlog that is there already for many years. Now, with respect to the blind trust, my understanding of the blind trust is that this should be used where an individual has assets. You do not want the individual to necessarily give up their assets because they are in public life. But with this blind trust, and I understand Minister Abrams did speak about that. The difficulty is that that is not stated in the legislation, really. Minister Abrams' understanding of how it should work. What is clear in the legislation is that there is a reduced reporting requirement because you set up a blind trust. And therefore, it seems to weaken the ability of the commission to investigate. So that is something that we would like to have examined more closely to ensure that the blind trust is not abused or it is not a mechanism to avoid disclosure. We would also like to ensure that where there is a limitation period, that if the period during which you can bring the person to justice has expired through the willful actions of the individual, we would like to know that that individual could still be pursued. And then I think everybody agrees that the commission needs to be provided with adequate resources, and this is going to be one of the very important points in setting up the commission, because practically all of the agencies that have this responsibility to investigate, even the ombudsman, which we set up years ago, and have not provided the resources that the ombudsman could function in any meaningful way. We have an Auditor General, yet the Auditor General complains about not having resources. So now we're going to set up an Integrity Commission, and the trend to me, it would seem to be that the commission is going to complain about not having resources as well. And this is the reason that I think there have been a couple of interventions where individuals have talked about the Auditor General. And this is the reason why the Auditor General comes to mind, certainly for us, because the Auditor General engages in a process where he is able to discover information, and he's already engaged in that process. So it would seem to me that there should be some nexus between the Auditor General's report, if not the Auditor General, because what we really want is the report. We don't necessarily need him, except that the Auditor General could be called upon by the commission itself. But my concern is that all of that work that the commission, that the Auditor General does, that we should not go over that again. That should be used by the commission. And if the commission wants the Auditor General to come to make a presentation, they should be able to do that. But we have to look carefully at our resources. The other point about resources has to do with us volunteering the idea of the commission entering into exchange of information agreements with foreign agencies. Now, I don't know if that is a requirement in some piece of legislation somewhere, but if it isn't, we shouldn't volunteer it, because that agreement to provide information to foreign agencies is often a burden on agencies in Barbados. I do not see that the commission is going to provide any other information than what the Financial Intelligence Unit can already provide and request, and what the Barbados Revenue Authority can already provide and request. So if this is a voluntary thing, I would suggest that we don't need to do this. We already have procedures in place to allow foreign agencies to have information. With respect to whistleblowers, I support those interventions which suggest that there should be greater protection for whistleblowers. Certainly, in looking at the legislation itself, if a person were to look at this piece of legislation that deals with whistleblowers, I do not believe that they would come forward. If you look at what is called a protected disclosure, So it says that an individual then who is a whistleblower, and it says that a disclosure is not a protected disclosure where the public official commits an offense by making the disclosure or discloses privileged material or information disclosed to him in the course of obtaining legal advice. Now, if we are very practical about it, the individuals who might be whistleblowers, they might not know technically or legally whether they should disclose a piece of information or not. So we're making it extremely, so the truth is, after they read that, somebody will say to them, boy, you better keep quiet. Next thing you know, they prosecute you. That is what will happen with this. I've looked at other pieces of legislation where if the person is acting in good faith, even if the disclosure is illegal, as you would say, they're still protected under the legislation. I think the thing that has to happen is that the person or the body that the individual makes the disclosure to, that is the body that needs to protect the innocent people out there who have done nothing, for example, from those people being subjected to somebody saying something about them that is not true. But I do not think you should make the individual uncomfortable about coming forward with the information, because the truth is, technically, they may just not know. In terms of incentives, we have a recommendation that there should be incentives. So that is something that you could examine. I know a lot of people are not that happy about like giving somebody an incentive for that. Now, I would also like to speak about the outstanding initiatives and support individuals who have spoken about the fact that aspects of the Election Offenses Act and the Representation of the People's Act, they're both breached by politicians every election, and basically law enforcement turns a blind eye, or so it is alleged. In addition, there needs to be a Freedom of Information Act, which other individuals have spoken about. But very, very important in Barbados, we need to have legislation where when somebody benefits from wrongdoing, you must be able to trace those assets and confiscate them. That is the issue. If you confiscate them, the issue about getting $1 million, spending 2 years in jail and getting a fine of $15,000 would not arise. There's an assumption that you engage in wrongdoing, get $1 million and you keep it. You should not be able to keep it. And our recommendation, therefore, is that there must be very soon additional legislation, whether it is an amendment to the Proceeds of Crime Act or whatever it is, but we need to be able to trace those assets and confiscate them. So that is, I will end my presentation there.
Thank you very much, Ms. Eastman. Ms. Eastman and her team will be open to questions from the panel.
Thank you. Thank you, Ms. Eastman. We were going through your presentation, which is, as have been others before you, well-researched, well-presented, and it raises important points which we find very useful. And I want to go directly to one particular point which you raised simply because it was a point raised in an earlier presentation. As it relates to incentives and protections for whistleblowers, page 7, I've gone past it. You make the point under your recommendation number 1. Sorry, you make the recommendation in recommendation number 1 that the Governor General or the Commission should be invested with the capacity to hear a preliminary submission before exposing the whistleblower to making a more substantive report. And I just wanted to raise that simply because there was a counter proposal made earlier, and I wanted you to be able to elaborate a little bit more on your rationale for making this provision.
You said there was, what was the counter proposal?
There was a proposal that the Governor General was being ascribed the role, specific roles that should not be incorporated in this.
Oh, well, that is why I said, I believe the Governor General is a resource that we have, and I believe that we should use that resource. I have no difficulty whatsoever with the Governor General being more involved in these matters. I really don't. I don't have a difficulty with it. You know, there are lots of things that are tradition, but we can't continue to hang on to the tradition. The Governor General is a resource. The Governor General was a Court of Appeal judge, so has the capacity to do a number of things, and I really think that we need to engage the Governor General with whatever safeguards might be necessary, but I have no difficulty with that.
Ms. Eastman, I thank you once again for an excellent presentation, and to be honest, I might be so bold as to suggest, well, I won't, but let's just say it was very easy to follow, and the recommendations following behind each section made life very simple.
We know of your charm, Minister Abrams.
My one question, Ms. Eastman, and you cut off before this point, you proposed that the declaration of assets be available for public scrutiny upon request. One of the main focuses of this legislation is the confidentiality of the information, and to be honest, the bulk of the feedback that we're getting from people, especially people in public office or in statutory corporations or who may fall under the ambit of this legislation, is to ensure that their declarations are protected and used only for the purpose of intended by the legislation. Just take me to your thought behind publishing every declaration or having every declaration of assets available for scrutiny, because that goes entirely against what we're trying to achieve in the legislation.
I know the other side of the argument. I know that side of the argument. The other side of the argument is that essentially that's where everybody else in the world is going. And there's no reason really why you should want to keep your assets secret. The other thing is that the majority of people are not going to go to find out what's there. There are only a few people who will do that. You're not going to see the majority of Barbadians getting up early in the morning to go and see what assets you have or anybody else has. So it more so has to do with the trend in the world. And in terms of the declaration of assets, I don't believe that it is so detailed. It depends on the form, but from what I gathered from the legislation, I don't believe that it is so detailed that people would know absolutely everything about you. So that was mainly it, that is the trend, and the trend tends to become the international standard.
Just for the purpose of those, I guess, who are watching and who may not be aware, there are two bits of information or two documents which detail the interests of the person in public life. One is a declaration, which is actually intended to be quite specific, down to cash in the bank. And the other one is a register of interest, where you would say that, I don't know, you own shares in a company, you own a house, but you don't have to put the dollar value onto it. So that's just for clarification for those who might be watching and not know. Mr. Jordan?
Thank you, Chair. Ms. Eastman, I just wanted to find out if you could give, or if you have any suggestions, or more detailed suggestions, I should say, as it relates to the funding, the provision of funding. It's been an issue that's been raised in the presentation before. You focused quite a bit on it in your own presentation. Models, you suggesting anything in mind specific to how it could be funded so it can operate effectively?
If we actually go the route of of confiscating assets. That could help to fund the commission adequately. So I would suggest that that could be, actually be one of the things that could be done, that the results that come out from out of the work of the commission could actually be used to fund it, which is not exactly the same thing, but kind of the same, kind of a similar thing that you do with the utilities regulator. When they go before the utilities regulator, they pay to do that, to engage them. So maybe something similar could be done. Those proceeds should go to fund the commission.
So you're really incentivizing the commission?
Yeah. And hopefully incentivizing government so that they don't have to worry about that money, about raising that money.
Yes, Senator Cummings.
I have a question, Ms. Eastman. On the question of sanctions, we've spoken a lot about the other entities that really should be captured under this legislation but are not currently represented, and the related legislation where perhaps they could be captured. I wanted to ask you a question. I think I wanted to ask it earlier to a couple of others, but since you're here and you've given us great recommendations, I'm going to pose it to you. As it relates to private sector corruption, the role of the private sector and being able to capture those persons, you raised in your recommendations about sanctions what should be done in some instances in terms of fines. And the legislation sets out what should happen in the case of public officials. But there's a standard emerging, a trend emerging globally as it relates to private sector entities, that they be prohibited from participating in government contracting, procurement processes for a period of time. So in some instances, you have entities like, say, the Inter-American Development Bank. So they ban you as a private sector entity from participating in their contracting for a period of 2 years, or non-compliance with their recommendations a further period, which would constitute 5 years. Are there specific recommendations that you would wish to make, or you could make, that would then strengthen either this legislation or, like you've done in some instances, for the ancillary legislation that should go along with this body of work? Thank you.
Well, certainly that proposal that you put on the table, that recommendation about banning individuals from again tendering, that would certainly be useful, because I really think that in terms of sanctions, you do want effective sanctions, and that would be effective. Of course, you have to be careful about individuals setting up different companies and then coming again to you under a different name.
Are there any other questions for the guests? Thank you very much, representatives of UPP. Like my colleagues, I too am grateful and impressed by your presentation, and it will certainly inform our continued deliberations. We thank you very much for your encouragement.
Okay, what I would like to close by saying is really that the issue of corruption has to become a national issue, and that all parties must be engaged, including the media. That is why anti-corruption initiatives succeed in countries where the population is actually embarrassed by the thought that there's corruption in their country. At this point in time in Barbados, nobody is embarrassed. People just believe that that is how Barbados works. So I think we have to do a lot to get people to that stage, like people in New Zealand, where you're actually embarrassed when there are instances of corruption that are discovered. Thank you.
Members of the committee, this has been our final presentation for today. I have asked the clerk whether we've had any more individuals we have many more written submissions, but not everyone has accepted the invitation to appear and make an oral submission. So I would suggest that we adjourn today, and we can set date and time of our next meeting during the course of the next few days. And I would I would certainly want to, again, extend the invitation to members of the public who still want to make written submissions or who may consider making oral submissions to do so. The opportunity is not closed. But if there are no more oral submissions to be made, the committee would then go into its deliberations on the bill, which would not be streamed. So again, if there are any members of the public, any members of civil society who want to appear and make contributions orally, they should communicate with the Clerk of Parliament so that we can get you penciled in for the next occasion. Senator Tate.
Thank you, Mr. Chairman. I hear what you're saying, and I thank you. I would want to share with the members of the committee, though, that a number of persons have approached me who have indicated that they have an interest in making submissions to the committee, but because they're at work when we are sitting, it's not convenient, nor do they want to submit anything in writing. So I don't know if the committee would have considered doing town hall meetings for persons that could be accommodated after hours, similarly like how it was done for the town and country planning legislation. There are a number of people who have indicated an interest. They have various concerns that they would like to share, have questions answered. But it is that they either are intimidated by the chamber, they cannot get time from work to join the chamber, nor do they want to put it in writing because they just don't want to. So I felt that I should say that to the committee and leave it for the committee's decision. But I felt compelled to say that because I have been approached by a number of persons who are asking about town hall meetings.
Leader of the Opposition.
Thank you, Mr. Chair. That is true. I had 2 instances of such. But alternatively, rather than a town hall setting, I would want to suggest perhaps a night session. Night session.
Let me say that I think that the committee would benefit from the maximum possible interaction, but there are some issues which need to be raised in the context of the suggestion that we have a town hall type meeting. This very issue was raised or has been raised at previous select committee meetings, but the prevailing view of those meetings, and certainly it remains my view, is that this is a committee of Parliament and there are certain privileges that extend to the proceedings. There are also certain obligations in relation to Hansard reporting, which are required. And I suspect that there would be some logistical difficulties in extending this kind of committee session to a place outside. I'm not suggesting that it's impossible. I'm suggesting that it might take a considerable amount of time to put in place, and we have a limited life. It is 3 months from when? I know, but what's the date? I have no difficulty. I have no difficulty with having a meeting which could run a little later than usual, but I don't know that people should feel cowed by coming into the chamber. Is it the will of the committee that we could have a late evening meeting? Well, so be it. We will just need to set the date and time for that. We could start at perhaps 4:30 or 5 and allow people, all these people who've indicated to Senator Tate that they are anxious to appear. We should plan on that occasion.
You know, Mr. Chairman, mine was that
for a 5-hour meeting.
Town hall meeting and not Senate, so I don't know if a late evening would satisfy my persons. It might satisfy the
What
bishop's
difference would
person.
there be between a town hall meeting
They
and
don't want
a
to
late
come to
evening meeting
Senate.
in the Senate?
They don't want to come to the Senate, Mr. Chairman.
This is a select committee of Parliament, and I think we should encourage the individuals to respect the fact that this is a subcommittee of Parliament, and if they wish to appear and make a presentation, they should do so.
Or Senator Tate, you can encourage them to send their submissions via you.
Okay, so let us adjourn then, and we shall try and set a date and time and notify the clerk accordingly. You have any other business?
I do, but I believe it should be
Oh, I see. Okay, well, can we then ask that the video streaming be stopped? We can have a 1-minute stretch your leg break while the, no, but you don't want it broadcast, so we just need to make sure that we just